DJ Khaled, Convict Music, we the best. We taking over. Listen,
spread out with it. South Carolina, Alabama, Mississippi, on the North Carolina, Philadelphia, Virginia. From down in Miami, where it warm in the winter, on up to Minnesota, where it storm in the winter. Jacksonville, Tallahassee, Memphis, 10, holla at me. B&H-Town, Southside, Cloverland, Daddy, I'm the man out in Dallas. Better ass Cali, Catman, Cali with my eyes open valley. Blowing that spinning, going down Vinny. Drop 6, 4, 3, wheel, get switching. Red light stop, make it drop for the bitch. Out block 4, 5th, blow your head out with it. Anything you hear that I said, I meant it. Kane got the crown, then spit out with it. Say you need bricks, I said I get it.
if you want to, we can supply you. Got enough work to feed the whole town. They won't shoot you unless you try to. Come around and try to stop on our ground, 'cause we taking over. Said we taking over. Said we taking over. Said we taking over.
Black flag, we rich. Yeah,
Listen,
bounce. It's what I does. I get money every day I does that. It's how I ride. Black flag on the left, 2 hoes and ride. You better move. AK, I'm dead. Get shut up like Shine, that's on my neck. I'm big like Diddy, damn it, I'm with it. Cali, we did it. Biggie of my city. Please no fit it. Fuck it, I'm too pretty. The bread and get brain stupid. Silly. Money that come, run it like water. Mommy so hot, damn it, she Miami on fire. You better be. Might get shot on the porch of your fortress. Yeah, they see it, but no one reports it. I run in,
'cause
Rick
we
Rouse,
taking
follow
over.
shit.
Said we taking over. Said we taking over. Said we taking over.
BXTS, nigga.
Listen,
That when you see crack, better duck like the Mac, gotta ease past. Nigga, what shit? I don't give a fuck, I run these streets. Y'all talk that shit, I want that beef. I'ma tell you like a G told me, they'll come back quick if a nigga OD. Cash rule everything around me. I'm YSL, Versace. You can see me in that Porsche GT. Coming down Sunset, sitting on D. Feeling like Pac, all eyes on me. Fresh bandana and I'm blowing mad trees. Nigga, please, I spit crack every verse a key. Some say Cali, some say Khalid. 12 years down and I'm finally
if you
free.
want to, we can supply you. Got enough work to feed the whole town. They won't shoot you unless you try to. Come around and try to stop on our ground, 'cause we taking over. Said we taking over. Said we taking over. Said we taking over. Listen,
Birdman dead, I'm #1. Nigga can't make me wrong, so we got him done. Fucking with the family, I'ma give him some. Spent that conda, he didn't run. Sunday had a whole church singing a song. Why they had to send my baby home? Fucking with some niggas that paper long. Been a G in the game, now my son on the throne.
I am the beast. Feed me rappers and feed me beats. I'm untamed, I need a leash. I'm insane, I need a shrink. I love brain, I need a leech. Why complain on easy streets? I don't even talk, I let the visa speak. And I like my Sprite Easter pink. And my wrist special pub, but the mule is cooler. I have more juice than your jeweler. Touching, I will bust your medulla. That's a bullet hole, it is not a tumor. Red light, stop your rumors. I stay on track like a box of Pumas. I just rock with Junior. I am the little big
'cause we
Kahuna.
taking over.
One city at a time.
Temperature is 85. Trying to close my eyes, but something's on my mind. Thinking out through all the years. free. My friends surrounding me, we got the widow tree. It's just one of those days. No, it's not a phase, it's our mentality. At the liquor store, picking up supplies, party all night, waiting for the sunrise. And when the world starts catching up to me, I take one back and smile because the mood is right. Thinking about the summer nights, the summer nights. The moon is bright. Thinking about the summer nights, the summer nights. I'm wasting time. Thinking about the summer nights, the summer nights. Getting high. Thinking about the summer nights, the summer nights. No matter how far you go, no matter if you've lost control, if you're surrounded by rain and cold, there's always somewhere you can go and always go. Now the mood is right. Thinking about the summer nights, the summer nights. Moon is bright. Thinking about the summer nights, the summer nights.
It is time. Hello, I didn't see you there. It is a summer night. It's going to get rough tomorrow. At least in this area of the world. My name's Grant Spandelis. What a day. I don't know what's hotter. The temperature, the forecast, or the Karen Reed and John O'Keefe civil docket. Hello, Act Right You. God bless you. Thank you all for your support at Towel Channel. God bless you all before we even got started. You got us 1/3 of our way to the super chat goal. God bless you all. Welcome to the channel. Hope everybody's... Sorry, I burped. I'm drinking an energy drink. I gotta stay up late. What do you want from me? I got colitis. I got stomach issues. I burp sometimes, alright? So anyway, we got a lot of stuff to do. Alright? We got a lot of motions to talk about. Brian Tully's lawyer submitted a hallucinated case citation. Oh, you don't understand. I track every hallucinated case citation across the country. I track all the sanctions that the lawyers get. You don't understand. Now, Brian Tully's lawyer, to his credit, by the way, this dude has got like a second-degree connection to Leah Janduso. This dude's like the guy for like cops that get in trouble. Like I'm sure he's the union lawyer for the state police. So anyway, that dude submitted a hallucinated citation off the jump. We got to talk about that. But then there's just chaos. It's just chaos on the docket. You know, I feel bad for the clerks. One of Karen's motions with all the attachments was 3,613 pages. One of the motions from the O'Keefe family was in an alien language. You don't understand. I'm not talking about foreign language. It was in alien characters. I couldn't decipher it if I had the Rosetta Stone. I was so confused. I was like, wait a minute. I understand we have a lot of accommodations in Massachusetts courts, but you can't write in literal alien hieroglyphics. So anyway, then we got to talk about the motion to compel. Hi, Tiffany Bob. Hello, Tiffany Bob's mom. You're both wonderful. Then we got to talk about Karen's motion to compel Brian Albert and Nicole Albert and Jennifer McCabe and Matthew McCabe and Allie McCabe and Brian Higgins. Then we got to talk about Judge Gildea's order, not just about tomorrow, but also those 2 lines in Karen's briefs. To say Judge Gildea is mad, I tried to tell you all that Judge Gildea was, you know, a little ornery. You know, he gets a little mad. I get a little mad. Just imagine if I were the judge, all right? You know, you'd be like, he's going to read all this stuff. He's going to notice when we forget like an of between words. You got to think that way about Judge Gildea. And then you got to be like, he's going to get freaking mad if we do anything that offends him. So, like, we got to just be perfect all the time. Alright, I think Judge Gildea tried to telegraph this from the bench, you know, to both sides. He was like, listen, I'm a bit of a stickler. He said this from the beginning. All right, well, everybody learned what that means over the past few days, okay? So we got to talk about first, it really started with the order about Karen's motion, which was a response to Brian Tully's motion, which now needs to be amended because it had a hallucinated case citation, which could get you sanctioned. We got a lot of stuff going on. This is bad. Things are just completely off the rails already. I didn't think it would get this bad, but it's gotten really bad. But we also got to talk about tomorrow's hearing, because I'm going to go to that hearing, and you all are very, very kind. So I figured, you've been supporting me, and we're trying to get Towel down to the hearing tomorrow. So I'm going to take the train and then do other things, and then maybe go on a staycation. So. And there's a Venmo, Cash App, etc. Let's see if we can get Towel comfortable, situated, and through tomorrow. In any event, we're going to talk about this. I'm also expecting an email about something else. I hope they don't email me while I'm live. Just to those people who I'm expecting an email from, you probably should get back to me. This is unrelated to anything we're talking about right now. To the people who know who they are, who I'm expecting an email from, who shall remain redacted. I want to write the story, bruh. And I'm trying to be, deferential. Just, I don't mind if you respond while I'm on air. They're listening. They're probably like, oh no, is he just going to say it? I could just say it. No, I am a responsible Towel reporter, but I'd really like you to email me. The workday ended 2 hours ago. Maybe you work longer than that. Hell if I know. Anyway, that's going to be a big story, I think, when it, comes out. But I don't know nothing about nothing. Anyway. So yeah, let's go. That's something, maybe we'll talk about it. If I get the email during the stream, I'll tell you first. If I don't, I'm going to tell you. I follow the rules. That's why people respond to me. Except for the government of Ghana. They didn't respond to me one time. And I was like, come on, government of Ghana. Don't you want to get involved in Proctorgate? They didn't want to get involved in Proctorgate. Which, I understand. But anyway. No, this is a Towel cigar. I'm a war reporter Towel. So, I do not condone or recommend smoking. But, war reporters, like Edward R. Murrow, we get a pass. Hashtag war reporter Towel. It's very stressful to report on the war. So, yeah, hashtag war reporter Towel. Alright, so I'm going to take you through everything that's been going on. It's chaos. I can't simplify this. This is not boring, mundane, procedural technicalities. This is just chaos. It's actually chaos. And tomorrow is going to be absurd. Listen, I don't know if Judge Gildea has mood swings. I don't know if he's just nice one day, mean the next day. But tomorrow, I would be really, really scared if I were a lawyer that had to go into that courtroom. I'd be like, I would not sleep very well tonight. I would be really, really nervous. Judge Gildea is probably going to be like, I order you all to go to Fiji. I'm putting you on a C-130 and sending you to Southeast Asia. Don't come back until you're all friends. Your Honor, are you even allowed to do that? I don't want to hear any objections. Get on the damn plane. But why Fiji? Shut up! Mr. Rosenberg, get on the fucking plane. Listen, put me on the bench. It'll be the funniest thing. I'll order the lawyers to have love-based retreats. They'll all have to sit around and talk about how they love each other. It'll be great. I'll make them learn Spanish. Alright, so anyway, it all started, back in the 1980s when I was a little washcloth. Alright. Nanya, it's chaos. So, here's where we gotta start. Alright, Judge Gildea, he got all mad. Now, you can't do anything when a judge gets mad. Like, when a judge gets mad, he can send you to Fiji. I don't think he can actually send them to Fiji. But, you don't want to test the equitable powers of the court. He probably could order them to go to Fiji and hold them in contempt if they don't go. I mean, Judge, what's the judge who's trying to hold the Trump administration in contempt? The D.C. Circuit said he can go forward with it. It's a bit of a different situation than the, planes flying Venezuela or Ecuador or wherever the hell we sent them. But, he could probably order them to go to Fiji. Just put me on the bench. Let me just see what I can get away with. It'll be hilarious. Order requesting information from Defendant Reed. This is from Judge. This was a sua sponte order. This is where this all started. I knew things were going to hell in a handbasket when I saw this one. Judge Boasberg, yeah. Order requesting information from Defendant Reed relative to opposition to motion to quash filed by non-party Tully. So remember, Brian Tully tries to quash his subpoena. He was the former investigator. That was the head of he was the detective lieutenant, which is the head of the State Police Detectives Unit for Michael Morrissey in Norfolk County, or was. And under him was John Fanning, the first assistant, who in my opinion covered up the Sandra Birchmore murder because he used to work as a cop in Stoughton. Matthew Farwell, the man the federal government alleged killed Sandra Birchmore in Canton, by the way, worked as a cop. And also where Robert Devine ran the Police Explorers program, where Matthew Farwell groomed Sandra Birchmore from the age of 14. He was the second in command, John Fanning. He personally wrote the report exonerating Farwell. And then Yuri Buchanan was the sergeant, all right, of that unit. And then below them was Michael Proctor and some other dudes, like Nick Areno and Connor Keefe and Matt Duane and Kathleen Prince. I think that's all of them. There may have been a few other people in there. Anyway, so the point is, that was the unit. All right, so Brian Tully, he retired, just like Sean Good. We don't really know what the hell's going on with Brian Tully. I'll tell you that there were law enforcement interviews by the feds in April of 2025, 2025, right when Tully put in his papers. All right? Or literally like 3 days before Tully put in his papers. So, anyway, who knows why Tully retired from the state police. But Tully was there. So Mark Sir, CYR, ran this unit back in the day. And when Mark Sir was the detective lieutenant, Brian Tully, I think, was a sergeant. I think Yuri was a sergeant. I think John Fanning was just a trooper. But a lot of them knew each other through this thing called the B-Fit Squad. It was like this athletic team that participated in events. They ran, but they're kind of like they ran triathlons. Who the fuck knows? And they rode bikes. Sorry for cussing. They did things. I don't know. Whatever athletes do. Hell if I know. So anyway, these guys are paramilitary though. The state police are paramilitary. And this unit, it was run by Mark Sir back in the day. Then Tully took it over. And it's been detailed to the Norfolk DA forever. And my theory is it was an inverted hierarchy. But it's not just your regular, Rachel says, I just laughed out loud, a little washcloth. God bless you, Rachel. This unit's not a regular unit. Like, they got connects. And Brian Tully was like the ringleader. Now, he's an unassuming little bald, man. I'm 6'2", so a lot of people are little comparatively to me, but Brian Tully's, a little bald man. And, I'm mad, frankly. You shouldn't have made me mad with the whole thing with my mom and Michael Proctor's uncle-in-law. You're making me mad, all right? So I'm going to call you a little bald man. What the hell are you going to do about it? Don't make me call the Congress. I already did. Anyway, so Brian Tully's a little bald man. And he was in charge of this unit. And he was mean to Karen Reed. And he was mean to journalist Aiden Turtleboy Carney. And I think Brian Tully talked to Jen McCabe a lot, And I think Brian Tully talked to Kate Peter a lot. And I think Michael Morrissey was on, or at least talking to people who were on Kate Peter's secret Discord for the witnesses in the Karen Reed and Turtleboy trials. Now, I don't know if it's permissible for witnesses during active criminal cases to have a Discord where they all talk. Who the hell knows, bro? I don't know. That's way above my pay grade. I don't even have a pay grade. I don't know nothing about nothing. I don't know what you're talking about. But anyway, my point is, that sounds bad. And then, to add on to all of that, this unit, they weren't a regular unit, okay? I think they did bad things. I think they maybe patroned brothels. I think they maybe had some girls around them that would get them girls, and then those girls would get treated nicer than the other girls. You know what I'm saying? I think sometimes you could go to restaurants in like Stoughton, hypothetically Dedham, hypothetically Boston, and you could order girls, at the restaurant where there would be a dorm suite in the back? Yeah, that's what I think was going on. I think the cops were the enforcers. You were a girl, you worked those places, you got groomed into them, you stepped out of line, you caught false criminal charges. And which unit, wouldn't you know who won the pony? Charged Miss Tiffany Overstreet, Robert Devine's former romantic partner, who threatened to expose his operation in the summer of 2014. Who was the very unit that charged Tiffany Overstreet? Right after Jeffrey Epstein paid a visit to Stoughton, the billionaire's paradise of Stoughton. Right off 128, he went to an IKEA on July 8th and 9th of 2014, spent $355 at the IKEA, then spent $33 at a gas station, then went somewhere for a few hours, then went to a Dunkies and spent $3. Alright? The Dunkies is now closed. It's number 330881. Yeah, I just know that. So anyway, you know, then Tiffany Overstreet gets charged, and who's the victim in the case? Robert Devine, for an RO violation. And who arrests her for a felony RO violation with like 7 search warrants to Google and who the hell knows? None other than Michael Morrissey's State Police Detectives Unit. The enforcers. Yeah. You can read all about this in Aiden Turtleboy Carney's September 2022 article about the Sandra Birchmore case. Just search Turtleboy Tiffany Overstreet article. You'll find it. Now, Turtleboy didn't know he put all this together. Nobody ever knows they put everything together, because if you did, it's not even like being a genius. You would, if he had put that together back then, I would quite literally say his level of intellect is impossible. It would require some type of like prophet level intellect. But that's not to degrade what he did. I just want to point out, he just didn't put it all together. No one could have. I couldn't have. Are you kidding me? If I was putting together the Tiffany Overstreet story, do you think I would have been able to put together that the Norfolk State Police Detectives Unit, like 7 years later, was going to cover up Sandra Birchmore's murder, frame Karen Reed, and then like torment Turtleboy because he inadvertently stumbled onto the nexus that puts it all together? No. And that they'd use a private intelligence firm to plant people in Karen and Aiden's life to extract information from them that couldn't be obtained legally due to the 4th Amendment to the United States Constitution, and then launder that evidence for the purposes of these very civil cases. A plan that probably went back to as early as May of 2023, when the very civil lawyer for the various defendants in these and plaintiffs in these cases against Aiden and Karen went to the hearing and was in Norfolk Superior Court. So anyway, I know, and listen, I forget, Cop's daughter said Turtleboy was like, do I remember Tiffany Overstreet's name? It was like 4 paragraphs of one of his thousands of articles. I write a lot of articles. If you ask me, Grant, do you remember like this pseudonym or this person you wrote about in like the summer of 2023? Yeah, probably, but I gotta go read it. And I need to like really think about what I was writing, because I need to remember what I was researching. Aiden probably doesn't hear the name Tiffany Overstreet and think about it the same way I do, because I read all the case documents. He did too, but I got them all. I pulled all of them. Every single thing they did to her. Dude, they spent at least $50,000 worth of man hours on subpoenas for her. That was wild. Well, for a felony RO violation, they arrested Miss Overstreet. They dropped the charges in March of 2015. Listen. Nobody touched those little birdies. And what did John O'Keefe, the Boston police officer working at an undercover unit for child sexual abuse, what did him and Karen stumble onto in Canton? And what were they keeping an eye on? Was Karen helping him? Did you know? Hypothetically, I don't know nothing about nothing, but if you were working intel, local, state, federal, doesn't really matter. Do you know who has to get the call if something happens while you're on the job? Your spouse. You wouldn't know it, but a lot of the spouses of people in the intelligence community are read in. Dude, they're really good. You know how beneficial it is to have a woman with you when you're doing an operation? Dude, nobody suspects women. I don't know why. This is literally in the books. I don't know why the hell it's in the manuals this way, but they say straight up in the declassified documents, if you want to run an op, just use women, because people just trust them. People got into this. Oh, 1 second, train drop. I don't know how these people got involved in all of this, I don't know why it happened. I don't know what's going on, but that's the intro. There's a lot of webs here, all right? We're talking about connections that go back years. John, let me just tie this all together for you all. This web of witnesses. I think a lot of you know about these cases, but let me just tuck it neatly through a Hegelian syntactical dialectic for you in my style, as I want to do. So, you got all these people who know each other, all these witnesses and cops and corrupt state police detectives units and local Canton cops and Stoughton cops and the DA and rich people and child abuse and John watching them and Karen watching them, and who the hell knows what's going on. Watch this. Michael Proctor, which nobody knew about until the fall of 2025. Michael Proctor, the lead investigator on Karen Reed's case, and a very prominent investigator in Aiden Turtleboy Carney's cases, which are going to trial in the fall. Michael Proctor has a group chat. It's called the Potty Boys. I don't know if they watched like the Jackass movie and they were like, ha, we like running around in leopard print thongs too. Who the hell knows? Yeah, spouses don't get the same level of clearance. Absolutely, Stacey, but they get read in on it to the point where if you got in trouble or died, especially a foreign op, they have to tell your spouse. They're never going to tell the public, but they have to tell your spouse. They really do. And you got to be able to like send a letter to your spouse, and they got to be able to go tell like your contact what's going on. Spouses are very important, but I don't know nothing about nothing. I don't know what you're talking about. Mateo. Anyway, so tying this all together in the Hegelian syntactical dialectic, it's the Michael Proctor's group chat comes out, the Party Boys. You know, who the hell knows why they're called the Party Boys? I don't really understand. But Michael Proctor's group chat has a bunch of members in it. One of them is this cop, former cop in Canton. All right, and this dude got busted in 2013 in a sex for hire sting down in Brockton. Now, 4 months later, wouldn't you know it? Wouldn't you know who won the pony? That cop, Michael Proctor's friend, since 2013, and Kevin Albert, the Canton cop who investigated both Sandra Birchmore's death and John O'Keefe's death, are hosting a fundraiser at that former Canton cop's new gym in Canton in January of 2014 for who? John O'Keefe's then recently double orphan niece and nephew. John's sister tragically died in November of 2013. His brother-in-law tragically died on January 12, 2014. I believe his sister died November 23rd or November 27th, 2013. May God rest their souls. Immediately after those two kids were orphaned, what happens? Kevin Albert and Michael Proctor's friend, the former Canton cop that just a few months earlier got busted in a sex for hire sting, are hosting a fundraiser for John O'Keefe's then newly double orphan niece and nephew when they were babies. And Michael Proctor didn't know John O'Keefe. Interesting. Things that make you go, What exactly did John O'Keefe find out about what was going on in Canton? And what did Brian Tully know about it? And what did Michael Morrissey know about it? And how deep does this go? Was it recreational? If that's a thing? Was it systematized? It seems systematized, because I think the Farwells were groomed. So, bro, we're talking like generations now. What do we got, a generational like child abuse network in Massachusetts, where the girls and the boys who are like strong-willed get put in as cops, as enforcers, and then like the high priestesses and priests like run it from the background? Bro, no. Get out of America. There's 400 million of us. We're coming. Iran's got our back. Get out of America. If you worship Baal, if you hurt kids, you need to leave. You don't have a lot of time left. The feds are going to get you. They need fall guys. And you damn liberal commies are the perfect fall guys. You're not even fall guys. You did bad things. It's not a John Dean situation. You literally did bad things. and you're gonna go down. Listen, Sean Goodhead references to CSAM on his freaking phone. I almost lost it. So anyway, I told you it was going to come to a head. That's the intro to all of this. The implications of these cases are astounding. Astounding. Nobody truly understands. You think Black Mass was big? You think the story about William Delahunt, the old Norfolk DA, sitting in that restaurant in the 70s and seeing an extortion attempt by Flemmy on behalf of Whitey Bulger that inadvertently led the Norfolk DA, William Delahunt, to go to the FBI and try to get the case charged because William Delahunt was a material witness and the FBI wouldn't charge it because Whitey and Flemmy were cooperating witnesses, and that made the Norfolk DA and the state police mad, so they ran wiretaps on Whitey's Hanover Street garage, but the feds were running wiretaps on 95 Prince Street at the same time to get the Angelos, okay, who were the Patriarchas men in Boston, and then the feds blew the Stadies wiretap to punish the Stadies for being, mad, and the Norfolk DA at the time, and then in turn the Norfolk DA and the state police, they had friends, and they got retaliated against by Whitey Bulger's brother, who was the president of the Senate at the time, who filed a bill to fire the state police officers that worked for the Norfolk DA on those bugs. And then as a result, there's been a 40-year war between the FBI and the Norfolk DA and the Massachusetts State Police Detective Unit assigned to the Norfolk DA because of the fact that those state police and that DA inadvertently or advertently exposed Whitey Bulger and John Conley and caused the FBI to lose face. And you don't cause the FBI to lose face, they'll get you, even if it takes 40 years. So that's the context of this case. It's an octopus. It touches everything. It's a very important case, and it all comes to a head with Brian Tully arguing he wasn't a material witness. That's the context of where we're diving in now. Tully arguing he shouldn't have to be subpoenaed or deposed by Karen Reed in the civil case. Mind you, there's 4 civil cases. Karen Reed got acquitted in the criminal case, the second trial for John O'Keefe's death in June of 2025. All right. Now we have 4 civil cases. The first one filed by John O'Keefe's family in Plymouth Superior Court in front of Judge Gildea. That's what we're talking about today. That's what the hearing's about tomorrow. A second case filed by Karen in Bristol County against Jennifer McCabe and Matt McCabe and the Alberts and Brian Higgins, Ham, and then Michael Proctor, Yuri Buchanan, Brian Tully. That was filed in Bristol Superior Court. Then the Ham defendants moved it up to federal court. It's pending in the federal court before Chief Judge Casper. Right now there's a hearing coming up in July. It's probably going to come back down. It's a complex situation. I don't have time to explain conflict of laws to you right now as a doctrine, but you can look into it if you want. All right, then because state courts can apply federal law, federal courts can apply state law, and then cases can get sent back and forth between different courts. It's very complicated. So anyway, then forum, people don't understand when you're a plaintiff where you file. The forum is so incredibly important, but I don't have time to talk about that. Then there was another case, speaking of forums, that the Ham defendants filed as plaintiffs against Karen Reed and Aidan Carney in Barnstable Superior Court. That was for defamation and violations of the Unfair Trade Practices Act. And then that case got transferred sua sponte by the trial court to Judge Gildea up in Plymouth Superior Court. So we got 4 cases, 2 of them in Plymouth Superior Court in front of Judge Gildea, 1 of them still in Bristol Superior Court, probably going to come over to Plymouth Superior Court, 1 of them up at the Federal District Court in Boston. Everybody on the same page. Hello, Talmon Buddy. Hello, Kofi. So, it all starts with Karen Reed responding to Brian Tully's lackluster argument, which, by the way, if you go back and watch this last stream on Brian Tully's opposition to, it's called a motion to quash, Brian Tully's opposition to Karen Reed's subpoena, you're going to see me say, did somebody write this with AI? This is ludicrous. Well, wait till you see how this plays out. So yesterday, Monday, Judge Gildea, or it was actually last Friday, issues an order that by yesterday, Monday, June 29th, Karen needs to clarify something she said in her opposition to Tully's objection to having to be deposed by Karen's lawyers. And the judge says, Karen Reed's requested to provide the factual basis for the following statements in her opposition, which is paper number 132.2. 1. Karen, quote, buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions. And 2, quote, the manner in which other subpoenaed parties have been handled in this case. Now, what that means, in layman's terms, is judge is made. Judge feels that Karen's lawyers, by saying those quotes, implied that the court itself was giving special treatment. Notice the verb there. The witnesses are getting from who? The court. Okay, well, you just impugn the integrity of the court unintentionally. All right? So, I will say, though, and welcome to the channel. I'm sorry I haven't been adding as many towel wrenches as I'd like. I will say, though, this, you don't always just read what the judge is saying. You read the tone. And this tone was, judge was mad. All right? So that was the first thing. That's our, foundation. Then, judge issues an order right after that. Okay? I want to be clear. Right after that order came down. So understand the Colin Albert order in the context of how mad judge was 10 minutes before that, because judges can just change their tune in civil cases. Out of nowhere, judge says Karen's motion to compel Colin Albert's deposition is denied without prejudice. That means she can bring the issue back. Subject, so that means it's without prejudice, subject to further receipt of information as to availability of Mr. Albert from Colin's counsel. So that has to do with Colin Albert being in the military. So you can see judge is not preventing Karen from deposing Colin Albert. He needs more information. Then, judge does compel Colin Albert to produce responsive documents that are between January 28, 2022 and June 18, 2025. Or represent through counsel that none exist, to or from Karen Reed, John O'Keefe, Michael Proctor, Courtney Ellsberg, Kara Roberts, Chris Albert, Julie Albert, Brian Higgins, Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, Allie McCabe, Brian Albert Jr., or Yuri Buchanan, which relate to the circumstances of the death of John O'Keefe, any law enforcement investigation of Mr. O'Keefe's death, and the plan alleged by Miss Reed of Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins to exonerate themselves and implicate Miss Reed in the death of Mr. O'Keefe. So that was the order. And the deposition issue for Colin, you got to remember, all these things are going to be on the table at once. So the deposition issue for Colin is tabled for the time being. Now, at the same time, all right, remember, this all happens back to back to back. Judge Gildea issues another order. He's already mad, all right, about the integrity of the court, although it wasn't actually impugned. We're going to find out from Karen's lawyers. They do file a motion today explaining what was going on. Out of nowhere, we got an order that no one to this day, no one understands what this means. The only person I've seen make a guess at it, or at least the person who made a guess at it, was one of the people who knows, Michael Morrissey and the witnesses, Kate Peter or something. So I don't know what this has to do with. I don't know who leaked this. I do know what this means because I read paper number 112 and then the follow-up order related to paper number 112. But Judge Sua Sponte, okay? Now, this is what I want to talk through with you because we got a lot of things to talk through, but I want to talk through with you the particulars of why I thought this order was so weird. I was talking about with Towel Girlfriend today. She's very erudite. So, Judge says, I have been advised of information that allows for a reasonable inference of a violation of an order of impoundment issued by me. Okay. First questions. Who, and this is for the hearing tomorrow. So if you're tuning in tomorrow, if you're tuning in, figuring out what's going to happen tomorrow, I'll be there. I'm going to be live tweeting, hopefully. I'll be able to record. No live streaming is ever permitted in Judge Gildea's courtroom. Hello, Pick a Handle. Hello, Pat. Hello, Nunya. Hello, Free the First Amendment. Hello, Towel Friends. You're all wonderful. This is about tomorrow, all right? So I'm going to tell you, this is going to be wild. Why? Now, if it were just a routine procedural hearing, well, one, I want to take a staycation because it's going to be very hot the next few days. So I don't have central AC. It would be 140 degrees in my space. So, and that's just untenable. So I want a staycation. So, second of all, this is not a routine procedural hearing. There's a very important issue that the public needs to figure out. And that issue is what exactly was brought to Judge Gildea's attention and by who. So if you're, as I was saying, we need a baseline, frame drop, 1 second. We're back. So as I was saying, we need a baseline. 2 questions answered. You should write that part down. 1, who informed Judge Gildea of information? Number 2, what is that information? And there's a third question. What allowed Judge to make an ex parte inference that the information brought to his attention by parties unknown about information unknown leads to a reasonable inference of a violation of Judge Gildea's order? Now, why is this important to think about? The order in paper number 112, and we can just look at it if you want. I mean, that's what we should do. No, I don't want you to end my time, mass courts. I'm trying to review court documents. So paper number 112 refers to these numbers over here. All these numbers have meanings, okay? They're like packages of motions, all right? If you see point 1, 2, 3, 4, 5, or they're just individual things docketed. Paper 112 is not actually a paper. It's not a document. It's just a minute order from the court, all right? It just says, other interested parties, Michael Proctor's motion to impound affidavits and supporting material. So a lot of people got confused when they were reading Judge Gildea's order because they thought paper number 112 was the endorsement. No. That is the original motion, okay? And then there is an endorsement on the motion. Hold on one second. Where is it? Right here. There is an endorsement on the motion, okay? And this goes in not even as a paper number. It's just kind of, it's technically supposed to be printed on 112, but they don't have 112 as a document. What they do is they just put 112 with the endorsement, which made this very hard to understand. I understand. And so the endorsement, what we're actually talking about is this, okay? Endorsement on motion to provisionally impound additional materials submitted in support of Michael Proctor's motion for a protective order, number 116. Other action taken after hearing and having balanced the rights, and remember, 116 is here, okay? All that is an addendum to 1112. The actual ruling is on 1112. But it's referencing 116 because Proctor added 116 as an addendum. Okay? So it's referencing 116 but actually ruling on 112. I know. And this is about the hearing tomorrow. So it's important to understand. I saw a lot of people miss this on X, and for good reason. It's not easy to follow. What we're actually having a hearing on is this. Other action taken after hearing and having balanced the rights of the parties and the non-party deponent, Michael Proctor, based on the particular facts of this case, and taking into account all relevant factors, including, but not limited to, the nature of the parties and the controversy, the type of information, and the privacy interests involved, the extent of community interest, and the reason for the request, I find good cause to impound, and so order the impoundment for a period of 30 years. I find good cause to impound, and so order the impoundment for a period of 30 years, the affidavits attached to this motion. I recognize the fear of unjustified adverse publicity is not sufficient to constitute good cause. George W. Prescott, Pubco v. Register of Probate for Norfolk County, 395 Mass. 274-279, which is the pin site, 1985. However, a legitimate expectation of privacy ordinarily is sufficient to constitute. So, let's just put it this way. One second. I'm back. So let's put it this way, all right? The only thing we're talking about is Proctor's affidavits. Grant, can you tell us directly where to go to see you go over 112? No one has seen it. Oh, so 112, I just want to be clear, that's what we're going over right now. 112 does not exist on the docket. It is impounded. It's a motion to impound affidavits and supporting material by Michael Proctor. 116, okay, other interested party Michael Proctor's motion to provisionally impound additional materials submitted in support of motion for protective order. That's actually what is ruled on. 116 is an addendum to 112. 112 doesn't exist. 116 we can look at. Okay? But I want to be clear. 116 is the addendum. Okay? Notice how it's number 116. The ruling, as far as I understand, oh, I guess that is on 116. The ruling should be on 112, though. It's not 119. Hold on one second. It's right here. Endorsement on paper number 1112. Okay? So, there's no endorsement as far as I can see. The actual endorsement is on, this is a typo. It's actually on 116. 116 is an addendum to 1112. 112. Does everyone understand? 1112, as far as I can see, paper 1112 is not on the docket. Paper 116 is paper 1112, though. I just want to be clear. All right? Other interested party, Michael Proctor's motion to provisionally impound additional materials in support of motion for protective order. Okay? Then we go up to 1112. Other interested parties, Michael Proctor's motion to impound affidavits and supporting material. So what Judge did was just only rule on this. Okay? Hello, Miss Holmes. It's good to see you. Now, 116, okay, is this. It has to do with Exhibit A and B of his motion for a protective order. Remember, it's an impoundment order with, oh, don't worry, Lori, never, God bless you, Lori, you're so kind, never feel obligated. The whole point of this service is so that people can get access to information regardless of their resources, and your comments and questions and support are very helpful. But, God bless you, Lori, you're wonderful. Let me just say, this is what they're actually talking about. Because remember, a motion to impound... one second. Yeah, I don't know who that was for, but it wasn't for me. I was thinking it might have been a call about the thing, you know, but no, that would have been interesting. I had it muted, though. I'm a good man. The button, though, I've learned you got to click two buttons. It's not just a mute on the microphone you could just bump. It's also the... See, I clicked the mute on the software. All right, let's get back to this. But remember, so I get why people are confused now. There's the motion for the protective order, which is 1112. But then there's the motion to impound the protective order. What is the result if your motion to impound is granted? It's impounded. But the motion to impound has to be on the docket. So we have a ruling on 116, which has to do with the impoundment of affidavits submitted as an addendum to 1112. Everybody on the same page? T.A. Sarah's taking notes. This will be on the final 77 billion. Bonus points for T.A. Sarah for taking such good notes. All right. Now, why am I drilling down on this? Because this is what the hearing is about. You must understand. There's been a lot of debate. I can't tell you who brought what to Judge Gildea's attention. That's the missing variable, okay? But I've isolated what the variable is. This is what it's about. It's not about the protective order motion, okay? It's about, which had to do with delaying Proctor's deposition. It has to do with Exhibits A and B, which were either supplemented, I don't know when they got added to that motion, but which were added or attached to the motion for protective order. Those exhibits are under impoundment. Nobody knows what they are. When you move to impound them, you don't describe them. That would create a catch-22. So what you have to do is generally assert, I'm not a lawyer, this is not legal advice, generally, and that's what they did. So what Judge Gildea is having a hearing on tomorrow is his ruling on this document about those exhibits. All right? Judge Gildea's impoundment order, which was a ruling on Michael Proctor's motion to impound exhibits that were attached to his motion for a protective order. My pleasure, Paula. Paula, enjoy your towel wrench. All right, so we get it. Everybody's on the same page. What the hearing tomorrow is going to be about, inevitably, is something which, no, by the way, I have seen nothing about this. I like it. Let me just explain this. If a bomb falls somewhere on the earth, even if like a fire happens or an explosion occurs that's not from a bomb somewhere on the earth, a missile, a bomb, I'm telling you, I'm going to know about it immediately. Within, like, if I'm awake, within 30 seconds to a minute, I'm going to know where it happened. And within 10 minutes, I'm going to know if it's a problem or if it was an accident or some other, like, force majeure, whatever you want to call it. All right? I'm pretty good with dockets, case dockets, too. I read a lot of documents. All right? I'm disabled. It's hard for me to do things. All right? I sit around and try to read documents, distract my brain from my disabled body. So, I voraciously consume primary sources. I see fake accounts posting stuff. I see people changing their accounts. I see it all. People are like, great, how do you just pop up out of the woodwork and kneecap them? Well, I see it all. Just because I don't comment on it when I see it doesn't mean I don't see it. I'm just like processing it and like, oh yeah, like this person said that. Oh, now they're on that account. Oh, they use that. Like, I don't like write it down. I just make a mental note, move on. And then when it comes up later, I remember. And if I need to talk about it, I talk about it. I have seen nothing about those two exhibits anywhere. And trust me, I would know. Even the stuff that's like a false flag, even the fake leaks, even the stuff that's one side leaking something to blame the other side. I always see it. Nothing about that was posted. Nope. 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 Absolutely nothing. So, we are halfway through our super chat goal. We got time though. We're only 1 hour in. God bless you all for supporting Towel Channel. Hashtag send towel to the court hearing tomorrow. Anyway, so my point is, this is without question what the hearing will be about at 3 p.m. tomorrow in Plymouth Superior Court. I don't know where this was talked about, though. It wasn't talked about on X, I'll tell you, because I would have seen it. I would have. And maybe it was talked about somewhere, like, privately, and then somebody, like, screenshotted that. But I gotta know, I need to be direct. And my job here is not to be a critic. It really isn't. I just call it like I see it. You know, I did the same thing when covering the war. Like, I don't care what side you're on. Like, don't bomb children. I'm probably going to be mad. You know, and ideally don't, like, bomb the people you're trying to protect. Like, there's just, don't bomb the animals. Making me all mad. Alright? I just call it like I see it. And I was concerned, as you know, when Judge Gildea brought up ex parte information he consumed about Alan Jackson and Karen Reed's interview on some of the national morning shows. And I says to myself, wait a minute. That material is not before Judge Gildea on this record. How do I know? Because I know the record. It is, I think, maybe before him, maybe in the case that got transferred up from Barnstable, maybe one thing about it in like one line, okay? But that's not good enough. These cases are not joined. Joinder has not been applied. They might get joined, sua sponte, in the name of judicial efficiency, but they're not joined. Oh, to making it count. God bless you. Thank you for your support. Keep up the excellent work, Grant. God bless you. So I was already on God, as the French would say, on God. Hashtag Boozy Beauty, the 400-foot tall baguette biscuit of France. About extraneous information. Now listen. I'm not trying to be hypercritical of the judiciary. But you got to understand, with this case, what might look like an inane approach by either a third party or somebody that's your colleague or a lawyer. It's not, or an email to the court. Like, dude, it's not. Now, you can say what you will about Judge Cannoni, you know, being a little non-defense friendly in the Karen Reed case. But she never introduced any of those emails that people tried to send to the court ex parte. Why? Because it's inappropriate, fundamentally, to consider ex parte communication with the court. Do you know what the courts do in Idaho and other states if you email them? They drop that on the docket and humiliate you and say, don't ever do that again. So I'm praying, I don't know what it was, I'm praying that it was not somebody emailing the court. We can't have that. That's not how courts work. This is not the legislature. They're literally different branches of government. Alright? You got issue with that, take it up with the Constitution, not me. So anyway, my point is, I'm worried that that's going to be what we're going to get the answer tomorrow. We need a foundational question answer, which Judge Gildea has to answer. You have to tell people what is the reasonable inference that somebody shared something from Exhibit A and B. I would know if there were anything shared from that. No, there's been some like Yuri texts that got out, stuff like that. Nothing to do with Michael Proctor submitting exhibits to delay his deposition, right? Because the protective order was denied. Remember, the only thing that was granted was his motion to impound affidavit exhibits A and B. So, what are these? Doesn't the fact that I don't know, that we all don't know, speak to the fact that nobody, at least in the public arena, that vociferously consumes every detail about this case, voraciously, every minute of every day, literally, there's not a the interest in these cases spans the globe, every time zone. So there's not a thing that can happen at any minute of any day. Okay, the sun never sets on the Karen Reed and John O'Keefe case. 24 hours a day, 365 days a year, constant, no breaks. All right. Somebody would have seen it, and it would have been a thing, because it goes viral very quickly, immediately. So, I don't believe for 1 second that this has, is something that, like, was in public, so a lawyer brought it to the attention of the court. Nope. Nope. Which means, and by the way, I'm not ruling out the possibility that counsel, because this stuff's impounded, counsel, of course, could have probably brought it to judge's attention. We got to put that on the radar. Actually, let's vote on it. Sorry, got all stuffed up. There's a lot of pollen in the air. Let's vote on it. If you think that someone emailed the court in order to inform Judge Gildea about a violation of the protective order, put a 1 in the chat. If you think it was Judge Gildea just consuming information on his own ex parte, put a 2 in the chat. If you think it was a lawyer for one of the parties in the case bringing it to Judge Gildea's attention, press 3. And if you think that it was a leak by someone close to the Ham witnesses to try to smear Karen, press 4. A reminder, your options are press 1, press 2, press 3, or press 4. I'm going to have to run them back. Oh, good thing I have a replay. I have a live replay. Watch this. I know, it's great. I'm going to run your options back one more time. Hold on. In order to... no breaks. Alright? Somebody would have seen it. And it was something that, like... Which means... And by the way, I'm not... on the audit. Sorry. Got to... If you think that... let's vote on it. If you think that someone emailed the court in order to inform Judge Gildea about a violation of the protective order, put a 1 in the chat. If you think it was Judge Gildea just consuming information on his own ex parte, put a 2 in the chat. If you think it was a lawyer for one of the parties in the case bringing it to Judge Gildea's attention, press 3. And if you think that it was a leak by someone close to the Ham witnesses to try to smear Karen, press 4. All right, so we have a lot of 4s. We have a few 1s. We have some 3s, small amount. We have a lot of 4s. We have a lot of 2s, a lot of 4s. All right. Very interesting results. Wow. All right. Way more of you are interested in this poll than I thought. So let's do it this way. Our first poll was, how do you feel about all the court motions today? There were 300 of you that voted. All right. 38% of you said, Tal, we need you. Then 30% said, Tal, I'm overwhelmed. 21% said, I have no idea what's going on. 11% said, I'm concerned for the goats. So I'm just going to run this poll here. Who do you think told Judge Gildea about the protective order violation? All right, let's find out. I should spell those words right. Not proactive, protective. All right. So someone did it via email. A third party did it via email. Judge found it himself ex parte. What was the third option? A lawyer for one of the parties. It was a frame job towards Karen. All right. There you go. I put a vote. I put a little Bridget, you got a towel wrench just for that excellent input. Thank you so much, Michelle. I'm glad you like the intro music. I put a poll up so you can actually just vote. We don't have to keep track in chat. The poll will. That was cool to see all your. But so many of you put numbers in the chat. I couldn't determine the percentages. So then I realized, oh wait a minute, YouTube has a wonderful poll function. We're going to use that. All right. So you're prepared for tomorrow's hearing. Okay. Now we got a few more motions to read through. Some of them don't make a lot of sense, and then we'll talk about the AI hallucinated case. We're 6 out of 10 on the goal lotto. God bless you. That's true. You're also wonderful. All right. So. Picking up on the next document. It was a flurry of documents. All right. Where's the next one? Yes. Timothy Burke. That name's going to come up in a second. All right. And then there was the order to compel the state police to produce documents. This also came out last Friday. All right, and then the Massachusetts State Police orders Judge Gildea. This was last week, getting ready for tomorrow's hearing. This has to do with 473 emails. The non-party witnesses claim are subject to protection based on privileged attorney work product. Ms. Reed suggests that the non-party MSP has waived any objection as the right to make any privileges claim for 2 reasons. Because they didn't respond within 10 days. And then further, she says that they can't be privileged because the criminal prosecution is over. Judge Gildea disagrees. But Karen also says she's entitled to them under Rule 26b-3 because she has to substantially be the case, but the record before me does not provide enough information to assess the documents and draw such a conclusion. As a result, I'm issuing the following order. The MSP is to produce a privilege log, as it should have done a long time ago. Such privilege log is to be produced on or before 3 p.m. on July 3rd, 2026. Now, there's a footnote there that says, it's hard for me to get too worked up about the MSP's failure to produce a privilege log in this instance, given in another discovery dispute in this case, Ms. Reed has not produced a privilege log in response to a request for production served in October of 2025. Ms. Reed did not dispute the claim, but rather points to a Rule 9c conference not yet occurring to talk about the timing of when Ms. Reed will give the plaintiff the privilege log. So, anyway, you can see judges taking shots, even in motions where Karen is winning. Hello, Interpretal. How you doing? We're going through every single document to get ready for tomorrow's Karen Reed hearing at 3 p.m. in person only in Plymouth. All right. Now, Karen Reed then filed a response to the court's order regarding the opposition to the motion to quash filed by non-party Brian Tully. Now remember, that order of the court was that Karen had to explain the factual basis for why she thought witnesses were getting or seeking disparate treatment by the court in regards to their subpoenas. So we're going to take a look at what Karen filed. This was the response that Karen filed to what Judge Gildea requested. Now let's see if I can get British Reporter Tal to do this. Nope, it didn't find any text in this one. Let me see if actually I can do this with the text reader. My voice is a little tired. Alright. And you might be saying, what does that mean? Well, if you've never met British Reporter Tal, let me tell you, he's a special mate. Alright? You know, everyone loves British Reporter Tal. People love Pete Bunnytail a little more. His friend Francine, she loves him dearly, very much. We love you, Francine. But British Reporter Tal, see, I've had a little bit of the scratchiness in the towel throat. So it had to do with me covering the war for like 90 days in a row. Anyway, British Reporter Tal helps us. He's very smart. He says words, and then those words are up on your screen. And he's our British Reporter Tal. We love him dearly. Now, I got to make one thing happen to actually, like, do the whole British Reporter Tal thing. I got to translate the PDF, which was not uploaded OCR scannable. That's my towel wink. That's my towel wink and a nod. Wink is as good as a nod to a blind man. You lawyers, you listen to me. You upload your documents as OCR scannable, not for towel, but because disabled people who need screen readers are blind, mostly, or at least somewhat blind. Do you think that they have the capacity to take the PDF and upload it to a service that transliterates into text, and then they download the text file and then upload it for the screen reader? No. OCR is an accessibility issue. Listen to me, you lawyers. Just click the OCR button. Click the OCR button, like Rosemary Scapiccio said. It's not just for searchability and readability. It's an accessibility issue for disabled people. You damn lawyers, I'm going to make it a court rule. I'm going to talk to the legislature. They're liberals. They'll do
Date
it.
Filed June 29th, 2026, 10:24 a.m. Superior Court, Plymouth. Docket number 2483CV00692. Commonwealth of Massachusetts. Plymouth, SS. Paul O'Keefe, as personal. Defendant Karen Reed's response to court regarding opposition to motion to quash filed by non-party Brian Tully. In response to the court's request, DKT 135, the request, defendant Karen Reed. Reed provides clarification as to two statements contained in her argument against Brian Tully motion to quash, which are presented below.
Tal had a rebellion. British Reporter Tal, he had a rebellion.
Date filed.
All right, British Reporter Tal, would you mind starting again?
Defendant
He had a rebellion.
Karen Reed's response to court regarding opposition to motion to quash filed by non-party Brian Tully. In response to the
British Reporter Tal, you're making me all mad.
date filed June.
British Reporter Tal, I'm giving you one more chance.
In response to the court's request, DKT 135, the request, defendant Karen Reed. Reed provides clarification as to two statements contained in her argument against Brian Tully motion to quash, which are presented below along with additional portions of each that clarify Reed's meaning and were not included in the request. 1. Apparently, buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions, subpoenaed witness Brian Tully now seeks to stand in the same line by filing a motion seeking to quash his deposition. Emphasis added. 2. Rather, it appears that Tully simply watched the manner in which other subpoenaed parties have been handled in this case. Emphasis added. These two arguments refer to the fact that multiple third parties Reed has subpoenaed have either ignored such subpoenas, and therefore the court's commands or sought to evade. Date filed June 29, 2026, 10:24 a.m. Superior Court, Plymouth. Docket number 2483CV00692. which will likely leave her forced to conduct a dozen or more depositions during the final month of discovery in this case. 1. On May 20, 2026, Colin Albert informed Reed that he would be indefinitely unavailable for deposition after June 2, 2026, and continued to refuse to produce nearly all documents Reed sought. 2. On May 20, 2026, Tully, through his counsel, agreed to July 8 for Tully's deposition, which was moved at his counsel's request. 3. On June 1, 2026, Brian Albert served objections to producing documents well after the deadline to object had passed and, the next day, claimed to be unavailable for multiple weeks that followed his subpoenaed date. 4. On June 1, 2026, Nicole Albert served objections to producing documents well after the deadline to object had passed and, the next day, claimed to be unavailable for multiple weeks that followed her subpoenaed date. 5. On June 1, 2026, Jennifer McCabe served objections to producing documents well after the deadline to object had passed and, the next day, claimed to be unavailable for multiple weeks that followed her subpoenaed date. 6. On June 1, 2026, Matthew McCabe served objections to producing documents well after the deadline to object had passed and, the next day, claimed to be unavailable for multiple weeks that followed his subpoenaed date. 7. On June 1, 2026, Ali McCabe served objections to producing documents well after the deadline to object had passed and, the next day, stated that she was unavailable for her chosen deposition date. However, she later agreed to appear on such date with only 2 days' notice, and then testified that, in fact, she never had concrete plans, i.e. reservations, traveling companions, etc., requiring her to be away on the date of her deposition. 8. On June 5, 2026, third-party witness Michael Proctor filed his emergency motion for protective order seeking to continue his deposition scheduled for the next business day, despite having been properly subpoenaed in April 2026. 9. On June 16, 2026, Julie Albert failed to appear for her properly subpoenaed and noticed deposition. 10. On June 18, 2026, third-party witness Tully suddenly served his motion to quash after his counsel had previously accepted service of the subpoena on his behalf and requested that Reed reschedule it, which she did. 11. At no point before June 18, 2026 did Tully object to the subpoena's request for responsive documents. These events form the factual basis for the arguments referred to above.
Okay,
2.
so Karen's response, you can see it there, to Judge Gildea lays out what I think is really the focus. It's a good motion because you got to get inside Judge Gildea's head. What does Judge Gildea care about? We got a month to go before the discovery deadline ends in this case, which is August of 2026. Redirect Judge's focus. He's mad because you used the word getting instead of seeking in terms of what the witnesses were doing as to avoiding their depositions. Getting treatment versus seeking treatment. What do? Well, exactly what Karen's lawyers did there. By the way, shout out to all the Tao friends. You're all wonderful. I have excellent news. I definitely will be able to attend the hearing tomorrow. I'm going to be able to see Tao and Nana. It's going to be great. I'm so excited. I just appreciate all of you so much. I feel very supported and loved. And, I grew up supported, but not really. It was weird. I don't want to get into the details. But yeah, I just adore you all, and I'm so grateful, and I'm definitely going to the hearing tomorrow. I can tell you that. I'm very excited. That's confirmed. So, excellent news, everyone. Then I'm going to take a staycation, and then I'm going to visit my Nana. I'm thrilled. My heart is singing. I'm going to take her to her favorite restaurant. She's Italian. She loves a very specific Olive Garden restaurant, and that's where I'm taking her. It's gonna be on Tao. She's gonna love it. I'm gonna take a picture. You don't understand. She loves the Olive Garden. She's gonna be so excited. Can't wait to tell her. So anyway, I just wanted to pause to tell you all that. I'm very excited. I think the lawyers probably aren't excited for tomorrow, but I'm gonna do my best to cover it. We'll see what happens. So God bless you all. You're wonderful. I'll tell Towel Nana how much you all love her, and then I'll take a picture and I'll post it. And I'll post it right after I tell her, and I'll be like, Towel Nana, what do you want to say? The last time I went to, actually, let's do a quick pause, because I want to tell you all, just as a not a trauma buffer, but we got 2 more motions to go. Then I'm going to go for a walk, then I'm going to sleep, then I'm going to wake up and go on an adventure tomorrow. For someone with executive function, I don't know if you all understand. It's not that I want to do the same thing every day, but for my brain to function this way, I don't understand this concept of, like, you got to get to a place. Then, like, the train's going to leave. So you got to, like, you got to know how to, like, have the ticket for the train. Then you got to get on the train. Then you got to, like, you just wait till the train gets to the last station. Then you get off the train. Then you got to have the Uber. Then the Uber's got to take you to this other place. And then you got to go to that. I don't really understand. Like, I don't understand. I know a lot of you think, like, I'm very good at understanding a lot of things. No, I don't understand that stuff. It doesn't make sense to me. Towel Girlfriend's really good at it. That's why I'm such a good payer. But I don't get it. I'm so proud of all of you who, like, know how to do that. I think, it's part of my disability. And I'm not ashamed of it. But, like, not everyone can be good at everything all the time. And my weakness is emotional intelligence and executive functioning. I just happen to have very good analytical intelligence, okay? And as a result, I don't understand, like, how to do things like that. I don't really understand cooking. If I just could eat the same thing every day, I think that would be great. You know what I'm saying? All right, I'm going to show you a picture of Towel Nana. She's great. You want to see her? She's wonderful. Hashtag Towel Nana. My life is a box of chocolate voices. Yeah, that's true. You want to see Towel Nana? She's great. Look, that's me and Towel Nana. Hashtag Towel Nana. That's her. We can zoom in. So, the old mayor of Newton, she took away the lines from the lake, and I was all made. Well, my Nana was sad. She cried. And you don't make Towel Nana cry, okay? They took away these Italian road lines. Now, Nonantum down the lake, it's a very special place. It actually started in, like, the 1880s, because there was, like, some mills down there. Used to be an actual lake. It ain't a lake no more. But anyway, when it was a lake, there was mills. So all these immigrants moved down the lake. It's Adams Street down in Newton, all right? And what happened was the Italian immigrants, they'd come into Boston, and they'd live, like, in boarding houses in, like, Boston, all right? The old, like, East End, maybe South Boston. I don't remember. It was a long time ago. I wasn't alive. It was actually multiple hundreds of years ago. But anyway, they eventually got jobs, and they moved out to Newton, okay? So you had this thriving immigrant, like, Jewish, Italian, etc. community. Actually, the oldest the oldest temple in Newton is on Adams Street. I know the man who runs the shoal. He comes into this story, wouldn't you know it? The New York Times wrote it up. It was great. So anyway, the old mayor of Newton took the Italian line, the paint lines off the street, under the auspices of traffic safety. I just think she didn't like the Italians. The ward didn't vote for her in the previous election. And that made my Nana, who grew up down the lake, real excited. So I, not just me, some other people, but, I got friends. So, your towel gets made. It might end up in the New York Times. And there you go. And then we got the road lines back. So that's me and Towel Nana at the St. Mary of Carmen's Festival down the lake last year. Nana was thrilled that the road lines were back on the road, and I love Towel Nana very much. She's from San Donato, Val de Camino. Shout out to, there's someone who mentioned their family was from San Donato, Val de Camino. We should talk. My Nana's wonderful, all right? But you probably don't want to mess with Towel Nana. That's just all I'm going to say. Like, I don't mess with Towel Nana. Nobody should mess with Towel Nana. She's got friends. She's just Towel Nana. You just don't want to ask too many questions. I mean, it's a fascinating part of history. Give me like 5 years, and then we can talk all about what Towel's just very... We'll talk about the chicken coop, all right? Those of you who've been around, if you understand, there's like 5 of you who will get this. If you understand about the chicken coop, you'll understand what I'm talking about. But anyway, shout out Towel Nana. All right, we got to get back to work. Mass courts, would you be so kind? All right, let's go. We got more work to do. You want to see what this docket looks like? Karen's criminal docket was like 700 items. That was long. This docket is already getting miserable. I mean, let's just see if any new hearings were added. Tomorrow, nope, that's all the same. Look how long this docket is. This is what, when like Kyle and Dee Dee monitor the dockets. That's why it's such an honorable thing. What they're really doing is manually refreshing this constantly. You have to do it manually. And they're looking for new documents, all right? So, the last thing that we looked at was Karen's response to the court regarding opposition to the motion to quash. So, Karen updating the court. All right? Now, we're going to look at the... Oh, Otto says for towel, Nana and you. Otto, God bless you. You've been single-handed on. It's going to be great. God bless you, Otto. You're wonderful. You are appreciated, and you are most definitely a towel. You're also great. Otto's been a very wonderful supporter. God bless you, Otto. I'm so grateful for you. And all of you. You've all been wonderful. When we get a GOAT video, I just want you all to remember that it was the support of Otto and so many others who made it possible. Because you're wonderful. Now we have to look at Karen Reed's motion to compel Nicole and Brian Albert. Now this document is 3,100 pages long. Okay? I don't know why, but I just want to tell you right now, it's going to make Towel Computer. It would make any computer really made, but it's going to make Towel Computer made. He can do it. All right, he's a Towel Computer, but this is a hell of a motion. Okay, I've never seen anything like this. I don't know why it needs to be this large, but you know, it's America. Alright, let's find it. So it's going to be the 189 megabit PDF. Where is it? Yeah, it's right here. Oh dear goodness. When your PDF is 200 megabits, you might want to say to yourself, like, bro, what did I do? Like, what have I done? Now, maybe Karen had a lot of stuff. We're not going through all 3,163 pages. Nope. I know, Michelle, it's a hell of a docket. You really got to stay on top of it, too. That's why Melanie Little's so great. I have not received my Melanie Little sweatshirt. I can't wait till I get it. I'm going to put it on. I'm going to take a picture of it. I'm going to bring Pete Bunny Towel. He's going to be in the picture. Oh, also, it's Trial Channel's birthday. Everyone, do consider special shout-out and happy birthday to Trial Channel. I think of Melanie Little and Trial Channel because they both do great trial coverage in their own way. Special happy birthday to Trial Channel. Go subscribe. Just Google YouTube Trial Channel. You will find Trial Channel. She's the best. I made her a special Trial Channel cake. I didn't give it to her in person because it's, you know, a digital cake. But it's me as a towel, and I have my Trial Channel towel. I'm a Trial Channel towel. And then it's a birthday cake that says Happy Birthday Trial Channel. She's great. God bless Trial Channel. Keep up the good work. She deserves, you know, Trial Channel gets quoted or cited in court motions by the judges and by the lawyers. She's just like the best, you know. So hashtag Trial Channel. All right, let's continue. So this was, and I'm not reading 3,136 pages. Nope. No chains. But I will read. I will have British Reporter Towel if he can even do it, because I might have to do this myself. This didn't get scanned in right. I don't know if Karen's lawyer, I can't imagine Karen's lawyers, who are like very stickler, like for like professional formatting, would ever submit a document that looks like this. No. Does that seem like something Karen, like Alan Jackson and Damon Seligson would submit? No. This seems to be a scanning error by the court. I know their motions too well. I read them all. They would never, ever. You think Alan Jackson would sign off on a file? First of all, they might have like a spelling error. Everybody has a spelling error, except for federal judges. Their bosses. Never found one. Maybe 110. But anyway, the point is, you think Alan Jackson would look at that document and be like, yeah, that's cool? No. He did not submit this. It did not look like this when he filed it. This is a scanning error. Marsha, it's so good to see you. God bless you, my friend. Otto, you're the best. Yeah. Oh, Melanie apparently sent me a few pieces of merch. I'm so excited. One of them is the oh, Melanie said the package should arrive today. Wait a minute. Wait a minute. Wait a minute. Wait a minute. How do I do this? I gotta find something to play if I'm gonna go check. I guess I can do it well, I can't have this one read though, because it's not even gonna make sense. I wonder what happens if it tries to read this one. Let me just see what happens. I'm gonna go downstairs and check. There's no guarantee that this is gonna work, okay? If it's here, that would be so cool. Oh, I could show it to you all. That would be great. Marcia, you drive safe, my friend. You're so wonderful. Which one do I want? I want the one combined. Yeah. Marcia said, hi, Gran and everyone. I've been listening while I've been driving. Thanks for reading all this stuff. Getting back to driving. Have a super great day. You drive safe, my dear friend. God bless you. You're wonderful. I'll be reporting on Karen's hearing tomorrow. And we're also going to have this motion read. And while it's being read to you, I'm going to go downstairs and see if the Melanie Little towel merch arrived. I hear it might arrive today. I can't. I could, but the steps I would have to take to patch in to look is more complicated because of the encryption than me just, going downstairs. So that's what I'm doing. I don't know nothing about nothing. Anyway, so what I'm going to do is I'm going to have this motion read out to you. British Reporter Towel is going to be very confused because it didn't scan great. But, he's a British Reporter Towel, so he'll make it work. And then I'm going to reappear with merch, hopefully. So
2.
No, take it away, British
WR
Reporter
greater than
Towel.
UA, 4G. Commonwealth of Massachusetts. Plymouth, SS. Superior Court Department. Civil Action No. 2483 CV 00692. Paul O'Keefe, as personal representative of the estate of John Joseph O'Keefe 3. Paul O'Keefe, individually, John O'Keefe 2. Margaret O'Keefe, and Margaret O'Keefe. As grandparent, guardian of Kaylee Furbus H., plaintiffs. Filed. Combe, on Velth GE. Superior Court Dec YOES Ag Me C. Jais. Plymouth County Hour. June 29, 2005. Versus A. Clerk of Count. C&C Hospitality, LLCD, B, ACF McCarthy's, G&S Hospitality, LLCD, B, ACF McCarthy's, Waterfall Bar and Grill, Limited D, B, A. Waterfall Bar and Grill, and Karen Reed. Defendants.
Okay, I made a personal trip to check. It is raining. I'd like to let you know it is raining. I made a personal towel check. It's not here. I will keep. It's raining though, so I'm gonna check every bit to make sure because I don't want it to get wet.
Defendants.
But yeah.
NON Party Witness Lieutenant Brian Tully, S motion.
Okay,
NON
pause.
Party.
We're gonna listen to this motion now. All right. This is Karen Reed's. Oh, that's not the right one. Sorry. Good thing I didn't let it start reading. This is Karen Reed's motion to compel Brian Albert and Nicole Albert. I'm a little bit out of breath because I got really excited and I then realized it was raining. So I was like, oh no, I can't let it get rained on because, the shipping box might be strong, but it can't withstand a rainstorm. It's torrentially downpouring outside. But no, it's not there. I checked. Hashtag towel Melanie Little merch. I know. I love the rain too. Listen, my reaction and concern was not because I don't love the rain. I love the cool. It's nice. It's going to get rough tomorrow. But this is like the storm before the heat dome. But anyway, I was more worried about the integrity of the shipping box. So I was like, oh no, I hope it's not just sitting out there. But it was not. I cleared all the areas. All right. Sorry for that slight interruption. I'll read this personally. Defendant Karen Reed respectfully requests that this court compel Nicole and Brian Albert, Matthew and Jennifer McCabe, Allie McCabe and Brian Higgins, collectively the delinquent non-parties, to produce documents and attend their depositions pursuant to validly issued subpoenas. Specifically, the delinquent parties refuse to produce required documents and refuse to show up for depositions, on required dates pursuant to the subpoenas. As a result, Reed seeks a court order requiring the delinquent parties each to immediately provide 3 non-overlapping dates for deposition between the date of to provide 3 non-overlapping dates for deposition between the dates of the court's order to July 17th, excluding June 6th and July 3rd, and produce all responsive documents pursuant to the subpoenas previously served within 10 days of such order. The delinquent non-parties counsel accepted service of the subpoenas to each of them on May 5th, 2026. A true and accurate copy of the correspondence regarding acceptance and the subpoena themselves are attached as Collective Exhibit 1. How something. Colin Albert, Brian and Nicole Albert's nephew, the delinquent non-parties. However, unlike Colin Albert, Brian and Nicole Albert's nephew, the delinquent non-parties did not serve objections to the subpoenas within the 10 days provided by Mass Rule of Civil Procedure, paragraph 45, D something. Instead, almost 4 weeks later on June 1st, the delinquent non-parties counsel served purported objections, objecting to everything and producing no documents, and then indicated that the delinquent non-parties were available for the dates included in their subpoenas in early June and mid-June, and that were not available, and that the subpoenas were merely proposed dates that they apparently reject unilaterally, and accurate copies of the delinquent non-parties counsel's emails and the attached responses and objections are attached as Collective Exhibit 2. The delinquent non-parties counsel did not provide any explanation for their unavailability, writing only, "With respect to the depositions, our clients are not available on the dates proposed in the subpoenas," and listing dates he said were available, almost all of which were on or after July 20th. Thus, nearly a month after they were served and just 9 days before the depositions were set to begin, the delinquent parties purported to unilaterally postpone all of their depositions except for one a month or more. Footnote 1. As described in Reed's pending motion to compel Colin to appear and produce documents, Colin, who is represented by the same counsel as the delinquent parties, seasonably, so in time, objected to the subpoena to him, but then refused to produce documents and failed to properly provide available future dates for deposition, then belatedly at the last moment indicated that he would only be available for 2 single days the very next week when counsel was not available and not available afterwards. The rules do not permit non-party subpoena recipients to control the timing of their own depositions. Of course, Reed's counsel was willing to accommodate reasonable scheduling conflicts and concerns, and was willing to reorder the delinquent non-parties' depositions or take them on other dates within the same time range, but that is not what the delinquent non-parties have unilaterally declared. Reed is forced to wait until the limited mid-July through mid-August dates the delinquent non-parties proposed. The court's discovery period, which Reed has worked diligently to comply with, will be placed in significant jeopardy. Therefore, Reed requests that the court order each of the delinquent non-parties to provide 3 non-overlapping dates immediately for the next 30 days, except for June 26th through July 3rd for deposition. Finally, regarding documents, the delinquent non-parties have directly violated Rule 45. Their objections, if any, were due within 10 days after service. They did not file any objections within that period, nor did they request an extension of that time. Rather, the time during which they had to object came and went without objection. 17 days after the Rule 45 objection period expired, they emailed what they called objections. These objections, however, have no effect under the rules. Moreover, this is yet another example of unexcused delay, which the court should not countenance at this juncture among any counsel, including the delinquent non-parties counsel, who are watching every hearing in this matter. Failure to object to a subpoena within the time provided by the rules ordinarily results in waiver of such objections, especially where there are no extenuating circumstances. Resolution Court vs. Awash, summarizing, failure to timely object to discovery requests constitutes waiver of objections. Oh, that's useful. So that's going to be number 92-1767, 2021, Mass Super, Lexus 2 at 3 to 4. So what? January 8, 2001. An unpublished opinion? The only time you see it cited like that is when it's unpublished. That's odd. Still counts as an authority, but it's normally, if it's cited like that, yeah, normally it's unpublished. You don't normally cite to Lexis unless it's an unpublished opinion that only appears in Lexis. And then there's another case, which is from the First Circuit, in regards grand jury subpoena. 274 F3D 563 576, explaining that the party, quote, the party that fails to submit a privilege log is deemed to waive claims or privilege or work product protection. And then you also got Pons v. Walter Kitty Portable Equipment, Inc., number 225, U.S. District, Lexus 93919 at 6, DMass, May 16, 2025. That also might be unpublished. Quote, but it still counts. Failure to timely and properly object to the subpoena generally constitutes a waiver of all grounds for objection, including privilege. Then you got Burroughs Corp v. Dataware Sources, Inc., number 86608, 1987, U.S. Dist, Lexus 1033-4 at 2, DMass, April 28, 1987. When objections to a subpoena are not filed within the time provided by the rule, the objections are waived. So it comes from the First Circuit. That's good. Wait a minute. That might be an unpublished First Circuit opinion. Might be from the district court. Yeah. Those are weird citations. They're legitimate, but I mean, it counts. It definitely counts. But it means it's not litigated that often. Therefore, Reed also requests that the court order each delinquent non-party provide all documents responsive to Reed's subpoenas within 10 days of such order. All right. Now, that's not coming up until the motion to compel the hearing. I think that's July 10th. So then you got a bunch of lawyer emails, all right, where they're fighting, I'm going to guess, about this. Then you got whose subpoena is this? You want to look at people's subpoenas? You want to look at Jen McCabe's subpoena? Let's do it. I know. This is what you've always wanted to do with your Tuesday. You've always wanted to see Karen Reed's subpoena to Jen McCabe. Oh, the Jen McCabe subpoena. I didn't even know. I should have figured it was in here. Normally they just attach them. All right. What did Jen McCabe have to turn over? Brockta. Ooh. Hold on. We're good. So this is the Jen McCabe subpoena. Oh, you have a life, Sandy. Look at all your towel friends here. You're wonderful. God bless you. Welcome to the channel. Jen Kitty, thank you so much for your kind words. Welcome to the channel. You all get me a little bit late tonight. I do have to figure out, what I'm going to do for my staycation. I have ideas. You know, one of them involves the Olive Garden with Owl Nana. But that's all I've really thought about. But the point is, I'm invigorated. It's raining, so it's cooling down a little bit. It's going to be rough tomorrow. But anyway, I'm glowing. I'm in a good mood. We're going to do this. You're all wonderful. So it's my pleasure to be with you all this evening, and I owe you this duty so you can be well and suitably prepared for tomorrow's hearing. And because I got to go do my in-person towel thing, literally the only way you can see what happens is if you go to Plymouth, which is great. I mean, it's down near the water. You know what I'm saying? But you got to go to Plymouth. So I'm going to go down there, you know. It's going to be great. I'm going to see Mr. and Mrs. Sweeney. I'm sure I'm going to see Miss Boozy Beauty, the 400-foot tall, baguette-based Queen of France. You know, if France wins tonight, they're probably playing now. She's going to be all happy. Are they winning right now? I can't really do the "Are you winning, son" meme to Boozy Beauty because she's the 400-foot tall baguette Queen of France. So I guess I'd have to say, "Is your team winning?" It'll be back in a sec. We're back. Hello. So my point is, France is winning. I'm thrilled to report to you that France is winning. Oh, I only graduated law school. I am not a lawyer. Thank God. Listen, I think lawyers are great, but you know, I don't really want to take the bar. I think lawyers are wonderful. I'm glad they do the work they do. But listen, I was trained by a guy who was trained by Jürgen Habermas. So I made my academic legacy. I made my footprint being taught by a guy who would sit with us in class and be like, "You damn lawyers." He was this nice old German man, And he knew Professor Habermas. I don't know if he ever met Adorno and Horkheimer. I think he did. I forget. It was really cool, though. It was like being in the legitimate like tradition of Hegel. It was so cool. So anyway, he would sit with us in class, and Habermas's big critique of legal rationality in between facts and norms, and also a theory of communicative action, is basically like, you damn lawyers, like talking, you use ends justify the means reasoning, and then you wrap it in like the ostensible veneer of like pretty legalese, but really what you're doing is subverting our democratic institutions by alienating participatory democracy, which Habermas thought was based on cogent public discourse. Wink. So anyway, I, being a little washcloth, you know, I was all academically interested before I became very disabled. I was reading John Rawls, you know, and John Rawls wrote Theory of Justice in 79, Political Liberalism in 89. You got to read both. You should also read his Dewey lectures from 85. Very interesting because it explains his political turn, as it's called, and then also why Rawls becomes more of like a reasonable pluralist in political liberalism as opposed to an apologist for like a comprehensive form of neoliberalism that you would see in Theory of Justice, which was a precursor to what of history, which then became a precursor to the book Bush Doctrine and PNAC. Anyway, my point is, I was reading Rawls's Law of Peoples, which he wrote in 1997. It was kind of like how Kant wrote Theory and Practice and Perpetual Peace at the end of his life as like a capstone on his moral work. Same thing with Rawls. He wrote this like International Law of Peoples book, but in chapter 8 or 3, I don't remember, he called the Supreme Court the exemplar of public reason. And I got very mad because it made me think about how Habermas's critique of legal rationality points out the alienating nature of legalese, because Rawls said that the Supreme Court was the exemplar of public reason. And I immediately said to myself, I've been reading Gideon v. Wainwright since like I was 14. Okay, I've been reading the amalgamated decisions from Peter Iron's various chronologies of the Supreme Court decisions, and I know my Gideon v. Wainwright, and in that decision, the majority holding, it says that the layman is fundamentally unable to understand the adjudicatory process, the adversarial process at its most basic level. That means when you begin interacting with a cop. So how are you going to tell me, John Rawls, that public discourse and the cogency thereof is embodied in the superfluous ends justify the means legalese-based reasoning of the Supreme Court of all people? Absolute nonsense. Public discourse and the cogency thereof is made manifest in public discourse itself. That's why the work I was doing was centered on developing a quantitative methodology to examine the cogency of public discourse as an indicator of political legitimacy in liberal republics, which is another way of saying I was developing word clouds in the early days of machine learning and natural language processing, and then I was trying to apply that outside of the medical field, which is really where it originated. It actually originated in the DoD, but I don't have time to talk about that, and I don't know anything about audio spectrum analysis using an analogy to natural language processing, or the implications of that technology in the Boeing Warrior X system being revealed because Towell found out that a Saudi spy was involved in the original patent in 1985 with Paul Prado's father-in-law. You should have heard that call. Anyway, so my point is, you know, in the context of natural language processing with words, I would develop word clouds based on like a specific geopolitical or geospatial set of communications. Like, for example, I'd go to Twitter, and then as a researcher get anonymized back-end API data for like 2 years, ask them for everyone with a Massachusetts IP address set over those 2 years, populate a word cloud, do the same thing for the Massachusetts congressional record and public statements of all the elected officials or appointed officials, and then amalgamate that into a word cloud, overlap them. The degree of overlap in the Venn diagram is an indicator of political legitimacy. Scale it vertically, horizontally, comparatively, whatever. That was my contribution to discourse theory. So anyway, that's my point. You damn lawyers. I don't want to be a lawyer. I want to talk to them. First of all, I like to write laws. I don't really like to apply them. I understand how to write laws. I've written a lot of laws. My words are in your statutes. It's hilarious. One time Tim Bradle was in court with Aiden, and they come across this part of the section where it's like, the person violated Mr. Carney's autonomy. And I could tell Mr. Bradle looked up from that paper. He didn't say anything, but I could tell he looked over at Aiden, and Aiden looked over at him, and they were both at that moment like, God damn it, Grant. which is hilarious, but it actually worked to Aiden's benefit in that specific context. So anyway, I just throw my words in your statutes from time to time, because I have things I want to say. That's how you petition the government for redress of your grievances. In the context of what I was just explaining, though, I try to tell these damn lawyers all the time why their profession is foundationally subservient to those who write the laws, okay? If you're just enforcing the laws, and you're really good at that, then, bro, I find out who writes the damn law, be like, bro, we got to change a little bit of this, or change this or that, or forth. Okay, now your rule's different. And then they're like, wait a minute, I didn't have any say. I know you didn't have any say because you apply the law, you don't write the law. So anyway, that's why I want to be the president, because I like to do all the things. I like to monitor the administrative agencies, keep the large corporate interests in check, sustain local mom and pop industries, put dedicated levies on the excise tax to create 0% interest grant funds for locally owned companies so they don't have to pay 20% on the dollar for funds in the market because the big companies get it at 12%. And I got all mad. You can make me mad about one thing and I'll go write a law. You don't understand. I get all mad. So, yeah, that's what I do. And anyway, I guess someone asked, if I passed the bar, and that one made me go on a rant. I like lawyers. I think they're smart. They're fun to argue with. I like to play chess with them. But, it's like the episode of The West Wing where Mr. President watches it, Adam Deitch watches it. It's a great show. Where Mr. President's playing chess with, 7 people at once. And he's talking to Sam Seaborn about whether he's going to send Aegis destroyers to Taiwan and to the Taiwanese Strait. All right, it's 1999 or something. And they're talking, and Mr. President is playing 7 games of chess in 7 different rooms at once. And it's clearly a commentary on Zygmunt Brzezinski's book, which is really just somebody who spent way too much time around Kissinger, but also read von Clausewitz and Sun Tzu, and then thought that they were the McNamara when they weren't. You shouldn't be allowed to write books about geopolitics unless you've either been on the front lines or at least have some understanding of the impact of war. You can't be involved in sending people to war unless you know the human toll of war. That's how we got people like Zygmunt Brzezinski. Anyway, so President Bartlett's playing chess with Sam Seaborn, and Sam Seaborn, as the end of the game is approaching, he sees Leo McGarry, the chief of staff, come in with a note for Bartlett, and Sam Seaborn's like, let me guess how it all played out. How did you get the Chinese to draw down? How did you avoid war? How did you do it? And it had to do with Patriot missiles, actually. And Sam's like, you agreed not to put the Aegis destroyers in the Taiwanese Strait, and you agreed not to sell them the Patriot missile defense system for 10 years. And Bartlett's like, 5 years, but you got it. And Sam's like, I don't know how you do it. And Bartlett's like, well, you have a little help, you listen to everybody, and then you call the blade. And then everybody saves a little face and goes home alive, mostly happy in the morning. Politics and diplomacy is the art of letting people save face even when they lose. Anyway, I get a lot of stuff done. But I do, that's why I like Bartlett. So I have a what's next mentality. I will stay on something until I fix every component that I think's broken. But then immediately, my next statement to you is going to be what's next. You don't have time to stop. We fixed it. Don't stop. What's next? Immediately. Thank you for going to court tomorrow, says Michelle. My pleasure. God bless you. And we're going to continue. We have just 2 documents to go. Tomorrow's going to be very interesting. But yeah, this is my towel rant. Silent Dogs, it's so good to see you. Machiavelli says Silent Dogs predicted that heavy infantry is the only thing that matters in the end. I'm sympathetic to that view. Well, that's how this... Oh, we did it! Clumsy Clairvoyance and Michelle and Otto and all the other towel friends. I have wonderful news. ladies and gentlemen, before we begin our next motion, you have unlocked GOAT videos. Yes, it is a time for celebration. Look at that. Look at that. You unlocked GOAT videos. All right, so quick, after 2 hours, quick 2 minutes, you're going to get a GOAT video. Now listen, my friend Mimi, she loves the goats. She has a baby goat named Ellie, and this is her one of her favorite videos. Now, we lost our herd of goats, okay? We lost them on March 9th, 2026. They were forced displaced. Now listen, you know war has really hit home when the goats are getting forcibly displaced and having to flee in packs, herds of like hundreds through the through the streets of South Lebanon. And then Kyle has just posted that Brian Albert was subject to a neglect of duty and unreasonable judgment sanction by the Boston police. The documents have just come out, but we're gonna watch. I know, what a tease. Listen, who knew? Look at this. We have a whole new IA report related to Brian Albert. It apparently was attached as part of Karen Reed's motion. I didn't see that. I don't know where this came from. Well then, let's just say you came for the celebration and the goats. Stay for whatever this new document is about Brian Higgins. Seems like we're going to have a night. I don't want to stay any later than eat, because then I got things to do to prepare for tomorrow. But anyway, I'm going to get you a goat video. You earned it, ladies and gentlemen. You might even get a dance party. So we got Brian Albert things. We got goats. It's going to be great. All right. Somebody get Ray from Dallas. Ray loves the goats. Ray had a great interview with Turtle Boy. Did you know? Have you all realized stealthily? It's not even stealthily. It's because Ray's just very humble. So a lot of people, I think, don't realize it's the people who don't like run their mouths that like mostly are doing the heavy lifting. Has anyone noticed that Ray from Dallas, over the past year and a half, got probably 4 to 5 very major interviews before anybody else knew what was going on? He really nailed it. And it was because, you know why he was able to nail it? Because despite the fact that it's easy to get caught up in the polemics, even when I didn't agree with him on even the Turtle Boy case, which shows something about Ray's character. If you can go on Ray's show, as I did a year and a half ago or something, with an anti-Turtle Boy perspective, and come out with him being friends and friendly to you and listening to you, I mean, the man's got to have a good soul. He didn't agree with me about a damn thing, but he didn't insult me. That was great. So anyway, Ray from Dallas has gotten some of the biggest interviews in the context of the Turtle Boy and Karen Reed cases. I don't think anybody really realizes it. It's a shame. Maybe I should talk to Microdots. We got to tell this story. It's important, I think, the interviews that he did. They're very insightful. Not just the Turtle Boy interview last night, but he was on some stuff before anybody. Pro Karen, anti Karen, pro Turtle Boy, anti Turtle Boy, completely removed from all of this and just sort of intrigued by the fact that people seem to really care about these cases. Ray was the one who was willing to kind of just be I'm just going to listen to these people and just see what happens. And it ended up not with Ray's mind changing, but with the people he interviewed becoming more and more supportive. Not because he made them, but because he listened to them. And then they listened to him, including me. So, yeah, I don't know. Shout out Ray from Dallas. He's great. And people are yeah, but shock jock. Okay, well, I grew up on Howard Stern and the movie Private Parts. You can't shock me. Sorry, I understand people like to have their way of conveying information. Have you ever listened to Ray do his interviews, talk about politics, congressional races, that? Exactly. That, you have to be able to do both. Just because my style of entertainment is different than how Ray does it doesn't mean that his substantive contributions aren't extremely relevant. And that's why I think he's great. That's why I gave him my first interview after all this stuff started happening. I reward loyalty, and Ray was willing to interview me when I disagreed with him. So why wouldn't I go interview with Ray right away? When I'm now far more sympathetic to his perspective. So he's great. Anyway, these are the goats. They were displaced on March 9th through Beirut. This is them returning to South Lebanon. They're great. I'm not really sure what song we're going to do. We'll have to do that during the outro because we have some documents to review now about Brian Albert. But you did all absolutely unlock a goat video. Look at those goats. Listen, when Mimi sees this, she's going to love it. Those are goats. Hi, Kofi. Kofi's a dog. God bless you, Tripler Bob. Yes, and there are other ways to support Towel News. You can scan the little things on the screen. There's a Venmo at Grant-E1. There's Cash App, money sign Grant Smith Ellis. There's a PayPal, paypal.me/Grant Ellis. God bless you all. Hashtag save the goats. If there's one thing you take away from this today, ladies and gentlemen, let it be save the goats. All right, those are goats. We want to save them. All right. The goats are great. All right, we got to go back to work, though, because before we go on to our... We only have like 2 motions to go. So we have the reply from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Allie McCabe, Brian Higgins against Karen's motion to compel. All right. Then we have Karen's Sir reply. All right. And then we have Tully's like admission that his lawyer used an like hallucinated AI case. Wait till you hear me rant about that. But before we get through that, okay, we have this. All right. Now, this was apparently attached. I don't know if this is from a FOIA or if it was in Karen's motion. I don't know where Kyle got it. He's a Kyle. You know, if you've never met Kyle Sharkey, I've never met him, but he's a Kyle. So, you know, he just does Kyle things. Things just appear. I don't know. He does FOIAs. He does the FOIA and found out thing with the wonderful Emily C. And Corey Hopkins finds documents. Documents just up here. You know, and that's why I understand when sometimes when people are like, Grant, I don't understand how you follow all these documents. Well, I don't know. I guess when I see a document, it takes like this picture of every page in my mind, and then I just know what it says. I'm not really reading them. I just like take a picture, and then it's imprinted in my mind. And it's cool. It's very quick. That's how I speed read. Like that, yeah. I just absorb the information. It just kind of like is there because I saw it, but I have to see it. Imagine if I could do that without even seeing the documents. That would be clairvoyance. No, I have to look at it. But once I look at it once, yeah, I remember the numbers, like the IDs, the Dunkin' Donuts store, the amount of like a purchase at a store, etc., etc. I remember it all. It's just there. I call it my mind map. It's like a computer. It has a bunch of folders, but I don't have to click through them. The latency of computers bothers me. In my mind, I'm just like, I want to think about that subject, and then I have all the folders. And I'm like, oh yeah, what do we need to access? Like that, what is the specific document in that tree, like of that person or that case? Where do we need what date, what? And then I just see it all as a folder structure. And then I just go into it. I don't really click. I just look. Sometimes I like tilt my head to kind of like poke around, but it's all just there. It's much more useful than like having to click on a computer. That takes forever. Imagine having to click through all those folders. It would take forever. I need instantaneous. So anyway, I don't know. It's apparently some form of didactic memory. I don't know. I asked them to study it. The powers that be. We'll see. That's above my pay grade. But I remember some. But I have to care about it. Some things I don't remember. I don't know what the score was of the Norway game. I think it was like 2-1. Yeah, Holland scored a really nice goal. It was kind of an accident. Still counts. Anyway, yeah, I think they won. Who did they beat? Côte d'Ivoire. Yeah, the Côte d'Ivoire goal was epic. Oh my word. And the first Norway goal was pretty good, but that Côte d'Ivoire goal, let me just tell you. So the Norway goal was from Musa, I want to say. I don't remember. Oh, he curled it. He bended it like Beckham. Listen, he was coming down the left wing, all right? And he crosses into the box inside the 10-yard line, maybe 7 yards from goal. This man is easily 7 yards like in front of goal and then 4 yards to the goalie's right. He curves that ball top 90 around the goalie to the goalie's left, It was incredible. It went in. It was one of the greatest goals I've ever seen. So that was Norway's first goal. And then Cote d'Ivoire comes up the right wing, maybe I think it was the end of the first half, second half, and one of their players, he pulled a Messi. He cut in. It was actually stunning. He cut down the right side of the 10-yard box right until he was at out of touchline there, and then he did a cutback. Okay, so he switched directions and then he cut the ball back across the face of goal. But what made it so impressive is in one motion, he cut the ball back across the face of goal and then changed his direction, jumped up in the air, landed on his plant foot, which was his right foot, and then simultaneously swung his left foot and then got the ball into the goal. This was all one motion. It was the craziest thing I've ever seen. Listen, I know what people are doing on a football field, on a pitch. That was freaking incredible. And then it was a shame, really, that Norway went through the way they did on the last goal, because it was more just like a cross into the box where Haaland wasn't paying attention, and it just literally clipped the back of his heel and directed into the goal. Still counts. Yeah, so that was great. Hell of a match. So yeah, towel. That's your towel sports report of the afternoon. When I watch a match, let me tell you, I watch it. I watch every single step that the various players take before a goal, after a goal. I'm watching it to the second. And then I remember it because I can see the frames and I can tell you about it. I'd be a good sports announcer. Hashtag sports announcer towel. Yeah, that was your reset because we met our goal. So I'm not going to set another goal. It wants me to, but I just want to say, actually, you know what? It is the last day of the month. So the way YouTube does it is it only counts through today. So we're going to do, for the first time ever, a bonus goal. Okay? Bonus goal dance party plus goats. All right, last stream of the month. We can't do a live stream tomorrow. I will live tweet or post from court if I get permission. God bless you, Laura. You are wonderful, and I hope you found wonderful towel friends here, and thank you for your kind words. So yes, we cannot go live tomorrow, though. So today's the last day of the month. So the channel, you don't get actually the donations for a while, but yeah, it's the last day of the month. All right, but we have work to do. So who knows where Kyle Sharkey, the infamous Kyle Sharkey, got this, but it's from Kyle Sharkey, and it's a internal affairs investigation from February of 2022 of Brian Albert. And it says Albert, I kind of knew, I didn't know what he was subject to. I never read this one before. Neglect of duty and unreasonable judgment. Unfounded. Okay. Unfounded against all of them? Well, what were they accused of doing? Eddie Hernandez, George Cardoza, Michelle Williams, Stephen Romano, Aaron Blocker. Oh, God bless you all. To those of you who've been sending support to the channel, you're wonderful. Let's see. So, they're the guys that were complained against. I don't recognize any of the names except for Albert and Eddie Hernandez. Alright. He was an inmate. He wants to file a complaint. Conducted surveillance. I'm enclosing for you with a picture of 4 masks, which my complaint is all about. During the days we were under video surveillance, scrapping for copper, I put a bag which had these 4 masks with them inside a trash barrel, blocks away from our apartment. So one of these detectives took that bag, which had these 4 masks within it, and took those masks to our apartment and took pictures of them on our bed. These masks were mentioned at my murder trial. So one of those officers or more of them set me up by doing what I just mentioned. I would like for this serious complaint to be investigated and those detectives interviewed and the video surveillance reviewed, which would show who took that bag out of the barrel and showed what was within it to other officers. Alright. 2009. The fugitive unit was not part of the search warrant. After the complainant was arrested. So it was not at that search. The search took place at a shared home located. 5 Boston police personnel took part in that search. Matthew Devane, Garrett Mitchell, Michael Walsh, Michael Griffin, and James Carnes. The foundation of this complaint surrounds a photograph of the found masks within the apartment searched legally with a search warrant. These masks found inside the apartment were photographed, not collected as evidence. They had no involvement in the investigation of the homicide. The group, led by Sergeant Detective Brian Albert, commonly were tasked with similar surveillance operations of persons and places for many reasons. Huh. Isn't Brian Albert a PI now? Wonder if he knows Marty Kraft. Didn't Marty Kraft know John O'Keefe? Why did Kate Peter work for Marty Kraft? Who's paying all these people? Why do people get cars? What's it have to do with Florida? We should go down to Naples. Maybe I already have eyes down there. Maybe I can be 2 places at once, unlike Hermione and Harry Potter. Anyway, that's interesting. A surveillance expert. I guess a fugitive unit would be an expert in surveillance. But, makes you wonder. Why did somebody spy on Karen go into Tom Eady's home in early 2022? It does make you wonder. Pick a Handle says, yeah, Brian Albert knows Marty Kraft. You know who else I wonder if Brian Albert and Marty Kraft know? Well, I don't know nothing about nothing. Michelle McPhee wrote a really good article about Tamerlan Tsarnaev and that other monster who did the attack. I was on the marathon route that day, thank God. I was not at the finish line. God bless those people. That was horrifying. I just want to let you know, Little Towel was a washcloth on that day. He was in grad school. He was in the mods, actually. It was my first year of grad school. I think I worked at the library or something. And the seniors at the library wanted me to go to the marathon. So I went to watch the marathon with the seniors. I think I had known some of them from undergrad. I went to grad school right after undergrad. So anyway, I'm sitting there. And probably the year or two after grad school started. And I'm sitting in the mods. And I think my friend got lost. So I walked over to some other mod. It's like this place on Lower Campus on mile 21 at Boston College. And so I was just kind of sitting on the steps. It was a very traumatizing experience now that I think about it. And I was sitting on the concrete steps on the patio. And I was talking to some people about the marathon. And And if I recall, BC football was very big. But anyway, all of a sudden, all these people, like priests and the RAs and all these cops, just start sprinting through these courtyards on Lower Campus. And this was old BC when Edmonds was still up. So it was just not what you see down there. That's what you see, Lower Campus, underclassmen trying to jump the fence. All right. When the fence was built, they called it the Iron Wall or the Iron Curtain, because you can drink in the mods. But anyway, so I'm sitting there on the steps, and I remember I called my sister, and I was like, "I'm okay, don't worry." And she was like, "What are you talking about?" And I was like, "Oh, you should probably turn on the news." And so that was very traumatizing. We were 5 miles, thank God, from what happened. But I remember, so I had a meal plan then in grad school. And I to go to the dining hall the next day, we had to go with a priest. The priest, like, that was their plan. It was a good plan. Their plan to get us, like, to the dining hall in case, because these guys were on the loose, you must understand. Like, they could have bet, we didn't know in the first, like, 24 hours where these, like, monsters were. They were just driving around. So they could have been in Watertown, Cambridge, Beacon Hill, and they could have been Chestnut Hill, anywhere. So when we went to the dining hall, they had us walk the students with, like, a priest who would shelter us. That was the plan. The priest was apparently going to protect us if these madmen, like, ran up on us. Because we couldn't, like, starve. They couldn't feed all of us. It was actually a very serious emergency. So that was their plan. It was a good plan. It worked. But yeah, I was very, like, confused. So my point is, you know, if you read Michelle McPhee's coverage of that, you're going to learn some things. Now, I don't know nothing about nothing. And I don't know nothing about nobody saying that they were supposed to bring those people to Mount Auburn, but instead they were brought to Beth Israel Deaconess Medical Center. I don't know nothing about nothing. And I don't know nothing about no phones being cloned, and I don't know nothing about anything, and I don't want to talk about that. But I do know that if you think hard enough about what's not being said, you know, you might put some things together. I don't know. I don't know nothing about nothing. Anyway, so continuing, that's a bit far removed. There's one name I think people might be able to eventually get to. Not really a private person. Like, they had a bunch of different roles. But I just think there's more to a lot of this than people realize. And I don't know why it involves Florida. I don't understand. Well, I kind of do understand. But I don't like the implications. I've never been to the Fontainebleau Hotel. I don't know nothing about the Fontainebleau Hotel. What are you talking about? Who's Max Eater? What's a Momo? Somebody on Twitter is called Momo or something, or they call people Momo. I'm like, bro, do you know who Momo is? We shouldn't be calling people Momo. You know, Momo is a name for, like, one person and one person only, and his name was Sam Gold in the files, or Sam Gene Connor. And he was the one who had the ownership with Frank Sinatra and Max Eater and Jack Ruby of the Fontainebleau. Now tell me, I wonder why, when Jack Ruby died, not in Parkland Hospital, but in his mother's living room or bedroom in December of '67, why was Max Eater there? And why did Max Eater tell the FBI that Ruby was actually, well, he went by Reuben when he was working with Momo's guys undercover. See, Momo and them didn't know that Max Eater and Jack Ruby were undercover feds. Are you looking into Jack Ruby's history? Oh yeah, he was a Lovestenite. That's an anti-Stalin communist in '29. So when Stalin took over the party, and, you know, Trotsky, the difference between a Stalinist and a Trotskyist is a Stalinist believes, and it's actually better for the West, a Stalinist believes that communism is, like, isolated within the domain of the country that created it. And then a Trotskyist believes that there's, like, the international workers' world revolution. Okay? So Trotsky lost the second or third Russian Civil War to who would take over Lenin's legacy and run the Soviet Union. He lost it to Stalin. When Stalin won the election in '29, he purged all of the anti-Stalin communists. Okay, they were called the white communists versus the red communists. That just was, they were like pieces on a chessboard, white versus red. The white faction in America of, like, the anti-Stalin communists were called the Lovestenites. Jack Ruby was a Lovestenite in '29. Already got flipped. He got flipped because he got expelled from the Communist Party for being anti-Stalin, pro-Trotsky. So, what do you think Jack Ruby did? Well, he became an informant for the federal government in the '30s and the trade unions in New York, all right, informing on communists. Then, in the '40s, he went into the Army, and by '45, he was doing signals intelligence by 51, he kind of disappears, and then he shows up again in 59 down at the Fontainebleau working with Max Eater, Momo, Frank Sinatra, and others out of the Fontainebleau Hotel, which is right next to JM Wave, which is right next to Interpen. And then all of a sudden, Ruby, who had like a $50,000 tax debt in the winter of 63, has no tax debt, but wouldn't you know it, by January of 64. But Ruby didn't go to any hospital after him doing the job on Lee Harvey Oswald down there at 9 in the morning or whatever it was, 2 days after JFK was shot. Oh, no. He went right back to Miami and was allowed to live out his life as Jack Rubin alongside his buddy Max Eater, working undercover for the FBI, keeping tabs on Momo's operation that was run out of the Fontainebleau. Then they tried to get involved in some sketchy construction company. It ended up going belly up. He owed a lot of tax debt. By November of 67, the feds had put his companies into forbearance. And by December of 67, he was dead by his own hand in his mother's house. That's the real story. So anyway, choose life. Choose a big television. Choose two-piece suits and football on the weekends. Choose life. Anyway, it really is what you make of it. You want to sit with the uncomfortable reality, or do you want to ask the questions, put together the actual sort of facts, and then stare into the reality? Anyway, that's why I don't like intelligence. You must understand, these cops, they are paramilitary. They're taught tactics that civilians don't understand, and quite frankly never will understand. We might have to use what's called BLR, bright line reasoning, when you're trying to get a cop to understand judicial precedent. All right, that's why bright line reasoning exists, but that's a gentle way of saying it. But we can't be teaching. First of all, they can't be paramilitary. That doesn't even make sense. And second of all, that's what you do in other countries. And second of all, they can't be doing intelligence gathering this way. Right, it's very dangerous. Forget about 702. That's dangerous. This is more. I'm just saying it hints at something bad. All right, so what does it say that Albert did? All right. Albert took part in an interview that took place on January 19th, 2022. Wait a minute. Brian Albert was interviewed by Internal Affairs 10 days before John O'Keefe's death? Do we know this? Wait a minute. Wait a minute. Isn't this like material to his state of mind? His motive? It was 10 days before. Wait a minute. I feel like we would have heard about this. That is breaking news now. Okay. All right. I shall write it up. Hashtag breaking news tab. Oh, Kyle Shucky's in the chat. He's a calf. Kyle, you have no idea how many times your name gets said every day in the form of "that's a calf." Well, hell, well then. Wait, what? All right. Breaking news. Former Boston police officer Brian Albert, the man The man who owned the home where John O'Keefe was found dead on a lawn in the early morning hours of 1/29/2022 was interviewed by the Boston PD Internal Affairs Department just 10 days before John's death. John also worked at BPD in the secretive sex offender registry unit. Okay. This information via a new document released as to that BPD IA investigation of Brian Albert via Kyle Shecky. Can be found on page 11 of 44. All right, so that post will go up shortly. By shortly, I mean like right now. That's pretty interesting. Got to do a close read, you know what I'm saying. I just wanted to go for a walk and then get ready for tomorrow. Got a busy towel day. We're not done yet, though. There's only one section about Brian Albert, but my word, did it have a big deal about that interview, that IA interview of Brian Albert that occurred on 1/19/2022 comes via a new document and by way of the venerated towel. Okay, Kyle, I referred to you as a venerated towel. I also got to get a siren emoji. This is big. You know, life rewards sometimes a close read. This is why my teachers used to always tell me, Tal, you're very smart, but you gotta read. You can't just find one sentence and then write what you want about that. Tal, that's not how it works. You gotta read the whole thing. And then you can comment. What if you missed something really important, Tal? And I'll be like, yeah, I know. You know, because I'm a Tal. So anyway, that was a big deal. And he said, Albert's like, yeah, I don't know anything about the masks in question. Foxy says, they put them on the lawn to take suspicion off of BA. No one would leave someone on their front lawn, right? Well, what if they couldn't move John? You can't be moving a body. You can't. It leaves DNA evidence. Any good cop would know that. You really can't. So you don't have an option. They must have had to come up with, you know, there's a window of time from like, I don't know, whenever Brian Higgins gets to the Canton police station, so what, like 1:30, maybe 1, around there. There's this weird window of time between 12:32 a.m. on January 29th, 2022, and like 2:30 a.m. that morning. It's the weirdest window of time because it's just enough time for something to happen and then you come up with a plan. All right? And one of the things that you immediately would say if you had a human body on your hands is don't move that body. Just don't. Maybe if there's not a lot of snow on the ground, but you can't be doing that. In an uncontrolled environment, the worst thing to do is move a body. Seriously, that body, okay, which is a dead person at that point, leaves genetic markers that are almost impossible to completely erase. I mean, have you ever seen any files on any case ever? Like, that's how they get people. So, yeah, that's my opinion. It's, as much as it seems counterintuitive, I think you got to think about it more, just my opinion, from the perspective of how can John's body be left in this area without anyone asking any questions, especially if we can call Proctor. Like, how can we make sure that if we call the state police, they just have enough to pull a Birchmore? I mean it. They just have enough to write a report that it's someone else. When they came up with Karen, there's not enough of a time window for them to have decided to blame Karen so quickly. I think someone, whoever they is, might have had a plan to blame someone else. I don't think Karen was the initial plan. The reason why I say that is, dude, there was so much panic between like 8 a.m., 6:30 a.m., 8 a.m., and 2 p.m., specifically about getting Karen's car. All right? Too much panic. All right? Which means they had to come up with that later, because if they had planned it out from the beginning, there would have been opportunities to... First of all, they wouldn't have done it that way, but I think it was just reactionary to Karen calling. I think the initial plan was something else. I don't know if it was a plow. I really don't think it was the plow, but you know what makes me think it might have been the plow as the initial plan? Did you ever look into Lucky's driving record? It fits. Let's just say he crashed into a few things. I'm not talking about the basketball hoop. He crashed into at least one thing, which, you know, people in Canton would have talked about. So, I don't know. I don't know what the plan was. I don't know what the routes were. I don't know, like, who knew what. I don't have enough information to solve this for you. If I did, I think I would be yelling it from the rooftop so people would know. But I have enough questions to narrow me in on like two specific windows of time. 12:32 a.m. to like 2:30 a.m. on January 29th, 2022. And then also 5:38 p.m. to like 6 p.m. on January 29th, 2022. If I could just like relive those moments, like go travel back in time and just be a camera, just watching everything happen in those 4 hours, I think I could put this whole thing together. Because those are the keys to this case. Whatever happened initially, and then what makes it so convoluted is I think the plan changed. Obviously, the humans are variable, and somebody had a plan, the best laid plans of mice and men. The plan didn't work, and they came up with another plan. All right? They knew that they were going to be able to do the, like, think about it. Who, hypothetically, how powerful do you have to be able to think to yourself, hey, listen, we know the guys who you can call when, like, a Sandra Birchmore case comes up. We know the cleanup guys, the cleaners. Not the plumbers, the cleaners. Alright? That's what they're going to call these guys. We know the cleaners. So we got to call specifically Proctor's unit. We got to make sure that it's like our guys. Do you know how connected you have to be? Dude, this has got to be some hell of an octopus. You got to have stones. First of all, you got to, like, that's like cashing in, like, a lifetime's worth of freaking, like, favors. That's crazy. Do you understand the institutional heavy lifting that has to be done for like a Farwell cover-up or a John O'Keefe cover-up? Dude, you got to write like 50 to 100 reports. If they fight it, it can really become an incident. You might have to write like 1,000 motions. Dude, like you're talking about calling in like a multi-million-dollar favor. You might even have to pay some of the heavy lifting. Listen, she litigates this case and it costs a couple million and the legislature won't subsidize it. You guys are going to have to pay out of pocket for some of these investigators. I don't know if we can win these cases. So anyway, what kind of network do you got to be involved in where you can do that? I've never heard of anything like that. Is it a service? It can't be a service. I don't believe it. I do not believe for 1 second that it's a service. And I don't believe it's the kind of thing where, like, hey, like, we called them in, they were our friend, we'll give them a little, like, spa vacation. Bullshit. Nonsense. To even make that call, you have to know that you have the pass to be able to effectuate the plan, which means you know about those things happening, and for whatever reason, you know that that's the unit you call, or that's the guys. So, I don't know who the hell, I don't know, it must be some, you know, they talk about, like, selling your soul, and then you get access to all this stuff. I don't think it's fame. Fame is a degraded form of power. Do you know how much fame sucks? Why would you want to be famous? Like, people leave me alone because I'm a towel, but people just look at me. I just walk around, you know, various places, and people are just like, some people come up and they want a picture. I smile, I give them a picture. But why would you want to be famous? Okay, real power, as the Brahmins say, Boston Brahmins, your name is in the newspaper twice. Once when you're born, once when you die. Right? So, I don't know. It doesn't really make a lot of sense to me, but I do think there is this sort of circle where, like, you know, you gotta worship Baal or whatever the hell they do. I don't know what the hell the demon is. And you gotta kind of, like, sell your soul, and you gotta participate in very devious sexual activity. And then you gotta do it with people who are pretending to be one thing in public, but actually different behind the scenes. And then it's just as simple as being like, hey, like, you know, we're all in this together. And that's bad. If that's what we're actually onto, which, I mean, I can't say that this specific document leads directly to that conclusion, but there's something off about how John O'Keefe died. Everybody knows that. But there's something off about, like, why was, right, if you look at the testimony and the details about John and Karen going from the waterfall over to 34 Fairview, why, if you look at the testimony, why was Matt McCabe trying to take John over to 34 Fairview? Why was Jen McCabe trying to isolate John from Karen and bring Karen with her in her car? The only reason John and Karen, that was the part I don't think people anticipated. The only reason Karen drove her car, I think, with John over to Fairview was because they were fighting that day over just general couple stuff. It was intense, but it had been more intense. And it was generally that day a smaller fight than other fights. And they were just kind of like talking it out, but they were mad at each other. It started over Dunkin' Donuts, but it was deeper than Dunkin' Donuts. It was more just like they were just fighting, not physically, just kind of verbally, just jarring. It was, out of all relationship fights, it was a tame one, but they were mad at each other. It's just the record, okay, of earlier in the day on the 28th into the 27th, really, into the 28th, and then in particular during the 28th in the lead up to Michael Camerano coming to pick Karen up, John up to take John to CF McCarthy's, where John and Michael Camerano met up with Karen, which is how this whole thing starts. All right. I think the unexpected variable, and this is my best understanding. I've never asked Karen. I don't know what Karen thinks. I don't know what she knows. You'd really have to ask her. But yeah, I really think that the variable here was Karen driving John over. Somebody was going to bring John to that house. It seems to have been Matt McCabe. That was based on what I recall from the trial testimony. It was going to be Matt McCabe. And then Jen was going to drive Karen to 34 Fairview. That didn't happen because unbeknownst to anyone, because Karen and John were like, you know, good blue bloods, they did not talk about their problems in public. Nobody knew they were fighting. Maybe Paul knew a little bit, but even Paul was like, listen, John didn't really tell me. Like, I didn't really know that much about it. All right? So I think that's what happened. Karen and John needing to talk it out is what led to Karen driving John over. And then everybody probably breathed a sigh of relief when John got out of the car on his own, because guess what? That's exactly what they wanted to begin with. Makes you think, doesn't it? It's a key part of this case people never really honed in on. What would that night have looked like if Jen McCabe drove Karen over, or went with Karen? Who knows what they were going to do with Karen's car, and Matt McCabe drove John. And maybe that's what it was. Like, Jen and Karen were going to go in Karen's car, and Matt McCabe was going to go with John in his car. Like, what would the night have looked like? Yeah. Listen. I don't really care what consenting adults do. It doesn't bother me. What I'm worried about is that there's like den mothers and cubs. And that shit ain't cool. Not with Towel. Just not in a lot of ways. Alright? I understand. But it's wrong. It's wrong. And the levels that this was operating at is not like, what's that movie where the people are in the woods? M. Night Shyamalan made it. All right. This is not like some society walled off from the rest of the world, running like a cult in Canton. No, that's absurd. This is part of like a structure you learn from a young age, and you get sorted. And this is what I've always sort of felt. Like, the girls and the guys get sorted from a young age. Like, some of them are like, you know, masters of the universe, like the high priestesses and priests. And then some of them are like kind of headhunters for like talent, you know, like the talent scouts, okay? But they're lower on the rung. They're more like madams. And then below them are like the like girls and boys who are like, you know, the like purebred or whatever they want to call it. They really refer to it this way, like the like ones who can like wear the mask in public, be a cop, be a like the position they need, and they get them out there, okay? Then they have their guys and girls. They're the ones who like are told, like, listen, it could be a lot worse for you. You are higher up in the hierarchy. You stay in line and you keep the people below you in line. And then you get the like vulnerable kids and the poor people who, instead of getting to be part of this power apparatus, are part of the underclass. These like people who live in open world cages, perpetually under the threat of criminal charges or family court intervention by the very people who are higher up the rungs in the chain of command. All right? That's what I think's going on. And I think they all know each other, and I think they fake it. All right? When they go out in public, I think they're like, I don't know who that is. Bro, a lot of people ask me what made me realize what was going on. It wasn't something someone said, but one time, all right, first of all, don't lie to Towel. Bad life decision. Don't manipulate Towel. And Towel's probably testing you, all right? You know, I love a lot of people, but like, don't lie to me. So anyway, I was asking about a very specific name many moons ago, all right? I'm not going to say the name because it would reveal who lied to me. And I says to the redacted person, hey, do you know the name, or did you know redacted? And this person, to their credit, they were smart, all right? Oh, thank you for that gold coin. You're wonderful. They were smart, all right? My pleasure, Simple Stacy. They were smart. But they still said back to me in a tone that betrayed exactly what I need to know. Blank, 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 blank. None of which I'm going to tell you. Excuse me? Really? All right. Let's see if that turns out to be true. It was the tone. Just a slight inflection on the wrong emphasis on the wrong syllable. And it told me all I needed to know. I was like, oh, you all know each other. I knew it. I knew it. I knew it. then I started putting it all together. All right? And that's how I was able to figure it out. And then I realized, like, okay, this all links together. Okay? It's a small circle. It's a couple of hundred, maybe a couple of thousand people. And they constantly need it. They're like masons. They can't reproduce. So they constantly need new initiates. I hate them. I hate them. I hate them. I hate them so much. That's why Brennan wore those checkerboard socks and the owl cufflinks. He's one of them. I knew it. And I don't even think it's Freemasonry, but that's one branch of occultism. No. This shit runs deep. These are the people who understand, like, what New Canaan means. Alright? I don't know who or what the hell they worship to, but I ain't down with it. Get the hell out of America. Leave. Now. You heard it. You know, let me just give a lecture before we go to these final two motions. If you've ever heard a single child, if you've ever worshipped Baal once, you really need to go. Alright? Nothing physically is going to happen to you, but juridically, you're going to suffer. Alright? It's going to not be pleasant. I don't know what the hell you were doing. I don't know what the fuck kind of metropolis-like existence you people were living. You're done. It's over. Alright? F. Scott Fitzgerald's Great Gatsby's got nothing on what you depraved lunatics did. Alright? You should leave. Peacefully. Quietly. And leave your money here. All of it. All of it. Tax cheating fraudsters. Seriously, you got a few years. You know what's going to happen when my generation is in charge of this country? You're not going to want to be here if you worship Baal or you hurt the kids. Don't even get me started on hurting the animals. Listen, you hurt the animals, just run. I don't know where the hell you should go. Go someplace where there's no freaking animals. And don't come back. But yeah, seriously, I know these people realize their time, at least in this country, is running thin. But you know who you are out there. If you hurt the kids, you consume that material. Like, it's over. They got the files. They know what you did. Come on now. So why are you here? Leave America. Leave. Leave. And pay the taxes that you owe. Tax cheats. It's one thing if you are destitute, but you're not. Pay what you owe. And stop stealing the resources of my country. And stop hurting the kids. Leave America now. You can have enough money to, I don't know, live on Corsica. No animals. No animals and no children. So, yeah, that's the plan. Yes, Chloe the dog in a wig was a federal informant. That's why she's in the Doggy Witsec program. Hashtag Chloe the dog in a wig. Listen, does nobody understand? It was actually Chloe the dog in the wig who solved the whole thing. Yep. She sacrificed a lot, ladies and gentlemen. She had to enter Doggy Witsec. It's one of the most highly classified programs in the entire government. Listen, when you're in Doggy Witsec, listen, you know some stuff, all right? And I'm telling you, if anyone can bring down this network, it's Chloe the dog in a wig, all right? She had a microphone. It was sewed into her fur. No one expects the dog. Not even Hank Brennan would expect a microphone in the dog. He's seen some shit. He wouldn't expect a microphone in the dog. Who puts a microphone in the dog? Is that even legal under various, animal rights conventions? You know what I'm saying? I'm just telling you. No one anticipates the microphone in the dog. It's a classic trick. No, listen. Tripoli Bob, I understand, okay? And you're not, well, listen. Part of getting Chloe the dog into the Doggy Witsec program is, you need a little, cover from time to time. So, I just, maybe don't ask too many questions about where Chloe the dog in a wig is, okay? Let's just go with, she's, pining for the fjords. She's running with her piggy friends in the fields of some northeastern state. She's looking at the mountains and just yearning for the days of looking at the man on the mountain, wherever she may be. Let's just go with that, all right? Because certainly no one would need to give her a cover story so she could disappear into the highly secretive Doggy Whitsec program. So anyway, Kevin from South Boston, listen. I'm not saying you know anything about the Doggy Whitsec program, but I understand the NDAs. I understand, but if you want to reveal to us just a little bit in the form of a modified limited hangout about Chloe the dog in a wig and the nature of the federal Doggy Whitsec program, listen, the DOJ is going to be pissed. You don't understand. You can't just go around talking about the Doggy Whitsec program. Do you know how many years of investment it took to figure out how to put microphones in dogs? Not to mention how many years it took to figure out what to do with the dogs when their cover is blown and you have to put them into Doggy Whitsec. It wasn't as simple as just giving them a wig. That was my suggestion. It didn't really work. So anyway, my point is, I love Chloe the dog in a wig. So Hank Brennan, I don't know about him getting dressed. I think he did put like a suit jacket on or something in front of court. I don't remember. But more relevant to his clothing choices, like if you're going to wear checkerboard, socks and have an owl cufflink, I get not that, I'm not in any of those groups. Do you think I would talk about him if I was? But most first and second, whatever the hell they call it, level, I don't know. I don't think those people have any freaking idea. Did you know the Hiram Abiff thing didn't even come about until 1700? Oh yeah, I've done my research. All right. So a lot of that stuff, I don't think most people, I think that's exoteric. Okay. Level 1 and 2. I think when you actually get up in that stuff, and they do have female orders because women can't be in the male orders, I think they kind of tell you what is basically just modern Rosicrucianism, which is probably a form of Neo-Cananism, which is just a very specific subsect of paganism. All right. And I've done some research on them. All right. But that's my opinion. So that's my history lesson. What this has to do with the Brian Albert Internal Investigations Report, it's where, 6 degrees of separation or Kevin Bacon. Whenever you listen to me rant about something, just assume the 6 degrees of towel methodology applies in, and somewhere along the line, we got there, all right? It probably required a few inductive leaps, but, overall it was worth it. Clumsy Clairvoyance says they'd appreciate Grant being a tarot reader spiritualist. I can't really do readings. Let me see if I can just sense something about Clumsy Clairvoyance. You have a very peaceful aura. Seem very happy. It's kind of special. It feels very, it makes me think about Nietzsche's 3 stages of soul and how very few people get past the 2nd stage into the 3rd stage. And that's my reading. So what do you think? Did I do a good job, Clumsy Clairvoyance? Oh, you are a tarot reader, spiritualist, so you can be a perfect judge of my reverse reading. Did I do a good job there connecting with you energetically? I think I pulled it off. Hello Lovely says they enjoy Grant rants. Yeah, by the time we're ranting, I've got through most of the substance. And I think finding that in the Brian Albert report was very important. Want to see if his name comes up again? Hold on one second. What's this dude's name? Not Dwayne. Devane. Michael Walsh. Huh. Alright. Alright. So there's no indication that he framed this dude with the mask, but that's just a conclusion. Who knows what they deleted. I can't pass judgment. What's this? Oh, the actual masks! Wow. These look like the run reports. Alright. And now they do an interview with him. Oh, dude, when they watch you, huh? I'm not going to reveal too much of this because it goes into how they do surveillance. Huh. Wow. Somebody should talk to that inmate. He was convicted in 72 or on a 72 murder, so he's got to be old. He might be dead. Somebody probably should talk to this man because he was convicted of a murder done in 72 and then also in 2009. It was a murder at a Tedeschi's. I could probably find out who this man is. I won't do that on stream. His name's redacted. Somebody should probably tell Marbury v. Madison. I bet Kyle did. We probably need to find this man. It feels like he might have got screwed here. You know, we investigated ourselves and found no evidence of wrongdoing. So thank you to Kyle Sharkey for that. That was very helpful. We got to get through our last motions, though. I went past 7 o'clock. I told you I was only going until 7. You all make me so excited, though you're also erudite and informed and wonderful to spend time with. And, you know, frankly, I don't know how to go on a staycation. I don't even know what, like, the word, like, time off means. Do you understand? I have not left this area, like, more than 7 miles since, like, 2017. It's been 9 years. I don't even, and then I went to law school. I don't really go anywhere. I don't really have any family. I don't really do holidays. So, yeah. Give me 1 second. I gotta reload Karen's case. Hold on. You can look at that while I'm doing it. It takes a second to reload because you have to go through. I'll just show you how you do it. So you search in civil, okay? And you want to click this one. Alright, now this is a long docket, as you know. Oh, that's wonderful, Kevin from South Boston. You are a towel. Anything else on the docket? Nope. Alright, so let's go to the memorandum of law in opposition to Karen Reed's motion for Brian Albert, Nicole Albert, etc. to testify. Or to be deposed. Alright? It's 35 pages. How many pages is the actual motion? Nope. Well, 8 pages. That's not horrible. I have to get you fully prepped, but I'm going to determine how much I have to actually read to you. Wow, there's some good stuff in here, huh? Alright, I guess I actually should read this then. So this is from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Alan McCabe, and Brian Higgins. They oppose the motion to compel. They say The Karen asked the court to find that the non-parties waived their objections to overbroad subpoenas because they served written objections outside the 10-day window. That request should be denied. Waiver under Rule 45 is not automatic. It's discretionary. It's a disfavored remedy for cases of egregious, unjustified, and deliberate delay. Here, the non-parties acted in good faith. Their counsel was in continuous contact with Reed's counsel, and the delay was modest and justified. More fundamentally, good cause compels consideration of the non-party's objection. The subpoenas are facially overbroad, demanding all documents, etc., all communications with a dozen named individuals spanning 4 years. The court granted the Colin Albert motion, by the way, for 3 years, 22, 23, 24, 25, so 4 years. This court already agreed at a hearing on a separate motion to compel an identical subpoena that such requests are overbroad. Yeah, no, he did rule that on Procta, but then Judge Gildea ruled in favor of Karen on the Colin Albert motion to compel under specifically the 4-year time frame and those communications related to the document production under those motions to compel or the subpoenas. Reed has also been on notice of these overbreadth issues since April 27, 2026, when non-party Colin Albert, represented by the same counsel and served with an identical subpoena, timely objected. There is thus no surprise and no prejudice with respect to the non-party's same objections to these subpoenas. With respect to the non-party's depositions, Reed noticed deposition dates on which the non-parties and their counsel are unavailable without first discussing mutually available dates. The non-parties offered multiple alternative dates for their deposition, all of which fall within the court's discovery scheduling period. Reed declined to accept any of the non-parties' proposed dates and failed to cite any legitimate scheduling conflict in doing so. Reed's unwillingness to coordinate dates for the non-parties' deposition violates the spirit of Rule 45. The court should decline to find waiver, consider the non-parties' objections on the merits, and deny the motion. So, we're not going to hear this till the 10th, by the way, of July. This is not tomorrow's hearing. I'm just getting you prepared. You get prepared very advanced in civil hearings. So, you sent me a wave. You're wonderful. I don't know who sent who a wave, but you're wonderful, Kevin from South Boston. All right, so continuing. What the argument here is basically, they already summarized that they did an umbrella paragraph. They're going to argue that they waived only by accident. Like they meant to respond and object within 10 days, but they didn't miss the deadline on purpose, so the court should not rule that as a waiver of their ability to object. Karen's asking for what's in effect like a death penalty, saying, no. Karen is arguing that they have constructively waived, by missing the deadline, their ability to object to anything about the subpoenas. Remember, think about what Judge Gildea is going to think about this. He's going to be like, wait a minute, you want me to now, you being the defendants, the non-party witnesses in this lawsuit, all right? You, Jen McCabe and Matt McCabe and Brian Higgins and Brian Albert and Nicole Albert, you all want me to say that I should rule on the merits of your objection to the subpoena, which you didn't file. I should have got this objection under Rule 45 within 10 days, or a motion for an extension of time, or some indicia that the parties had to agree to an extension of time, telling me that you objected to the service counsel. The deposition window ends in 45 days. You could have brought this to me weeks ago. In fact, you had an affirmative duty under the rules to bring this to me. That's the first thing I would say. And then furthermore, Karen is asking, remember, the sanction she wants is, Judge, I need to do this discovery, and we're running out of time. Order them to not have the ability to object. Remember, Karen's asking for more than just a granting of her motion to compel. Order, Judge, that they don't have the right to object because, well, you can imagine, ladies and gentlemen, they didn't object in a timely manner, and the discovery window is closing. All right? And then they also say good cause warrants consideration, and they say this is because the subpoena is overbroad, the witness is a non-party acting in good faith, the counsel for the non-party and the subjecting party, subpoenaing party were in contact, so they just cited the law under Levy. They say the subpoenas are overbroad. That argument's going to fail. They repeat the prejudice and surprise. They argue they've all acted in good faith. They say that their conduct was not egregious and did not evince a deliberate pattern or delay. Then they say the motion to compel document production should be denied. Remember, this is not being heard tomorrow. The motion to compel deposition testimony should be denied. They don't even want to have their depositions done at all because Karen apparently refused to accommodate the witnesses' quote non-availability. And so therefore they want to literally be let out of their depositions and having to produce any documents at all. Now I'm getting tired, but we're not done. We're not done. All right? You know how I know we're not done? Because now we have to read Karen's reply or surreply. These documents are getting exceptionally convoluted in their title. And this one's title is Defendant Karen Reed's reply to non-parties Nicole and Brian Albert, Jennifer, Allie, and Matthew McCabe, and Brian Higgins' opposition to her motion to compel. All right? Now, the only saving grace here for us all is I think I already wrote this one up. All right? So as a byproduct of having wrote this one up, I think I have the capacity to just have it read out, the whole summary. Karen does a really good job. She tears them apart. Her lawyers absolutely tear them apart. So I'm going to just have, and I think I did a good write-up. And my write-up is succinct. Tell girlfriend was like, your write-up meant that I didn't have to read the motion. And I was like, well, you should still read it, my love. But, you know, my write-up is pretty good. Oh, Clumsy Clairvoyance, you're wonderful. Skinny Chicken, I love your username. Thank you for your wonderful compliments. All right, let me go get, where is it? Where is this one? All right, where is it? Here we go. So I have a full summary that I wrote up. British reporter Tal's going to read it. He's smart, all right? And this is Karen's motion that we're going to be reading through, okay? But instead of us reading through, because remember, this is not being argued tomorrow, I'm going to have it summarized for you by British reporter Tal. We're going to have to read it again going into the hearing on the 10th. British reporter Tal, would you be so kind?
Conversation. : Karen Reed is moving to compel Nicole and Brian Albert, Jennifer and Matthew McCabe, Allie McCabe, and Brian Higgins to attend depositions and produce documents pursuant to non-party subpoenas in the John O'Keefe civil trial. As of now, the docket only has Karen's reply to the objection of those witnesses to Karen's motion to compel. Karen's reply argues as follows. Karen's central argument is that delay appears to be the goal, and not just a symptom, of the manner in which Nicole and Brian Albert, Matthew and Jennifer McCabe, Allie McCabe, and Brian Higgins, collectively, the delinquent non-parties, have responded to defendant Karen Reed's subpoenas. Those witnesses, says Karen, ignored the strict 10-day deadline under Massachusetts Rule of Civil Procedure 45, D.1, to object to the subpoenas, provided no explanation for missing that deadline, and belatedly claimed they were unavailable for more than a month after the subpoenaed dates. Further, in a Rule 9c conference, the counsel for those witnesses essentially told Reed's team to just accept the late dates they chose because, by the time the court rules, the time will have passed anyway. Karen also argues, as to objection waivers, that because the non-parties missed the 10-day objection deadline with no good explanation, their objections should be deemed waived. Reed cites case law holding that failure to timely object generally waives all grounds for objection. As to relevance, Karen argues, unlike Colin Albert, who claims he left the house before Reed and John O'Keefe arrived, these non-parties were undisputedly inside 34 Fairview Road on the morning of January 29, 2022. Their alleged conduct is at the heart of the plaintiff's claim that Reed spread a false narrative, causing him emotional distress. Any communications they have about the key events or that narrative are therefore relevant. As to any burden on the witnesses, Karen says, the non-parties never identified any particular undue burden with specificity, as required when objecting. Vague references to another party's, Colin Albert's, opposition in a different motion are insufficient and distinguishable. They are also plaintiffs in a related case, notes Karen, as many of these same individuals are plaintiffs in a separate defamation lawsuit against Karen involving the exact same narrative. These witnesses, argues Karen, voluntarily took on that role knowing they would have to gather and produce responsive documents. In sum, Karen offered to reschedule any deposition to other dates close in time to the originals to accommodate reasonable conflicts. The non-parties simply repeated the late dates they had already proposed and refused to move. Karen, thus, argues this forces her to take multiple highly relevant depositions in a rushed manner at the very end of the discovery period, rather than allowing her to take them comfortably within the schedule. Third parties' right to avoid undue burden does not give them the right to dictate the overall discovery timeline for the case. Karen then asks the court to reject the non-parties' waiver and, good cause, arguments, compel those witnesses to produce the requested documents, and order them to appear for depositions on dates that allow Karen to complete discovery in an orderly fashion within the existing schedule.
So there you go. That was the summary of this document, okay, which starts delay appears to be the goal and not just a symptom of the manner in which Nicole and Brian Albert, Matthew and Jennifer McCabe, Allie McCabe, and Brian Higgins, collectively the delinquent non-parties, have responded to defendant Karen Reed's subpoenas. In response to validly issued subpoenas, these individuals ignored Rule 45's deadline for objecting to documents production and belatedly claimed that almost all of them were fully unavailable for more than a month from their subpoena dates, evidencing their desire to obstruct Reed's ability to take discovery required for her defense. Indeed, in the 9C conference concerning these subpoenas, among other topics, the delinquent non-parties, their new name apparently, counsel, even suggested that Reed's counsel should simply accept the late deposition dates its clients had chosen because by the time this court heard and decided Reed's motion, all of the interceding time would have passed anyway. Rule 45 has specific deadlines and requirements so that a party to a case may compel witnesses to provide discovery in a timely manner while respecting the non-party's right to avoid undue burden. Although Reed has always been willing to accommodate reasonable scheduling conflicts by choosing new dates in the same time frame as a subpoena date, the court should not permit these non-parties to unilaterally impose their will on the discovery schedule in this case and prejudice Reed's ability to prepare her defense within the discovery period. Reed replies separately to the delinquent non-parties' argument regarding document production and deposition dates below. In their opposition, the delinquent non-parties claim that good cause and good faith support their failure and refusal to assert timely objections within the 10-day window set forth in Mass Rule of Civil Procedure 45D1, but they provide no explanation for why they ignored Rule 45's deadline. Instead, they simply rely on the very objections they belatedly asserted as a reason for the court to ignore the deadline. This court should reject that circular reasoning, which would render Rule 45 toothless. This is why, quote, failure to timely and properly object to the subpoena generally constitutes a waiver of all grounds for objection. All right. And then the delinquent non-parties then asked the court not to compel them to produce any documents based on a single paragraph in reference to an opposition filed in response to a different motion by a different party, Colin Albert. However, much of Colin's opposition is distinguishable because it focused on the fact that he claims to have left the house at 34 Fairview Road before Reed and John O'Keefe III arrived in the early morning of January 29, 2022. In stark contrast, the delinquent non-parties other than Allie McCabe were undisputedly in the house at the time, and their alleged conduct forms the core of the false narrative the plaintiffs allege Reed or promulgated, causing them compensable emotional distress. So we heard that. Then we heard the argument about Karen offering to reschedule any of the dates to others close in time to the originals to accommodate reasonable availability issues. The delinquent non-parties simply repeated the dates they had proposed in the first place, ignoring Karen's right to take the depositions comfortably within the discovery period, rather than facing the task of taking multiple highly relevant depositions in rapid succession at the end of the court's discovery schedule. Third parties' right to be free from undue burden does not allow them to unilaterally dictate the deposition schedule for this case in this manner, and the court should prevent them from doing so. So that's Karen's argument. Remember, we're ahead now. The motion to compel is not until July 10th. Now, on this, I can't believe that Brian Tully's lawyer did this. All right? Brian Tully's lawyer, okay, again, this is not relevant to tomorrow's hearing. Brian Tully's lawyer, remember, he's objecting to Karen's subpoena. And in his objection, remember, he's citing cases saying, here's why I shouldn't have to come to the deposition, give Karen documents. Look at this. He says, Judge, I want to file an amended motion for leave. I want permission from the court, motion for leave, to file a corrected memo of law in response, in relation to my motion to quash that subpoena. What he's saying is, Judge, listen, I screwed up. I screwed up bad, Judge. And Judge, please don't read that. And if you do read it, please read this correction immediately thereafter. Now, Judge doesn't have to allow this. Hello, Ann. It's so good to see you. God bless you. Hello, Dennis. It's so good to see you. But yes, so my point is, as I'm reading this document, ladies and gentlemen, I'm like, wait a minute. What did you do? You must have done something really bad. Because remember, Tully's citing legal ground to avoid being deposed and subpoenaed for a deposition and for documents on the grounds that are weak. He's saying he wasn't involved in the investigation of John's death. He was at the scene. He was like writing emails about the case, updating Coppenrath and others in the state police. He was intimately involved. He was talking to Jen McCabe, apparently. So anyway, notwithstanding that, you also, when you do a motion to quash, or what like Tully did, a motion to quash means asking the judge, like, please, like, tell them they can't depose or ask me for documents. Tully also asked for a protective order, which is not a protective order over documents. He was asking the court to issue a protective order to delay his deposition. To delay a deposition in light of a subpoena, you need a protective order. It's not the same thing as a protective order over documents, just so we understand. Anyway, so continuing. Tully has to submit a motion to quash or a motion for protective order. He did a joint. And then you have to submit a memo of law, okay, separate but attached to your motion. And then you got to do an affidavit. All right? And in that motion of law, memorandum of law, you got to cite to cases, okay? Like when you're a lawyer, you got to do this, all right? You have to cite to cases buttressing your position. Unless it's like there are some things that are either like novel or whatever. But on the whole, even if you're finding like doing a novel thing, you got to have some law from somewhere. Literally, you go to Black's Law Dictionary. I don't care. Go to like the pre-U.S. founding decisions in England. Find a case about the subject and try to argue that it's the precedent. You have to. And Tully's lawyer's like, listen, Judge, and this might come up tomorrow, it might not come up till the 10th. I don't know. God bless you, Dennis. You're wonderful. Tully's counsel, whose name is, what's his name? Tim Burke. Tim Burke was the lawyer for one of the cops involved in the scandal that, although didn't directly touch on Leah Genduso, like ended up leading to Leah Genduso like losing her job. And Leah Genduso was a state cop that got like exposed by Turtle Boy. She never should have been hired as a state cop. There was all sorts of crazy stuff going on there. And Burke represented like either like one of the high-ranking state cops that Genduso knew or his partner. I don't remember. But the point is, like, that was a cluster F. And Burke was right in the middle of all that. So, I don't know what the hell is going on here, you know. But anyway, because Leah Genduso was on that Discord with all those Karen Reed trial witnesses and the Turtle Boy trial witnesses. She's out in some other state now, though. I kind of feel like that's how they tried to make the op effective. Use, like, people from other countries, other states, and then the people you do have in the state have them fake and play roles that they're not actually believing in. Anyway, so Tully's lawyer's like, listen, Judge, I cited a case, an incorrect case. That's initially what he says. Wait till you find out what actually happened. Counsel respectfully requests leave to correct the authority Cronin v. Strayer, 392 Mass. 525, 534, 535. The correction does not alter the argument presented, the legal proposition for which the citation was offered, or the relief requested, and it's just to correct the citation and assist the court. Oh, is it? Is it, bruh? Is it? Because, you know, bruh, I read the actual document that you file. I don't just, like, listen to your summary. So you go into the next document, which is the actual proposed supplemental notice, which he needs leave to file. He can't even file it. He's got to get the judge's permission, because you can't just supplement a motion without leave. So because you're really depriving the other party of a right, okay, to respond when you supplement your response or motion. It's very convoluted civil motion practice. This is why you got to take Civ Pro, people. You got to know what you're talking about. I'm not a lawyer. This is not legal advice, but I did go to law school. Now listen to what Tully says when you peel back the glass onion. Non-party witness Lieutenant Brian Tully, retired through counsel, respectfully submits this supplemental notice to clarify and supplement the motion for leave to file a corrected memorandum previously filed in this matter regarding a citation in the memorandum of law filed in support of his motion to quash subpoena and/or for protective order. The prior motion for leave to file identified that the citation to McGuire v. Cunningham, 56, Mass Apps Court, 160, 164, 2002, appearing on page 6, section 1A of the memorandum was incorrect and should be replaced with Cronin v. Strayer, 392 Mass, 525, 535, 4 through 535, 1984. Counsel files this supplemental notice to state plainly, for the completeness of the record, that upon further diligent review, counsel has been unable to locate any reported decision corresponding to the citation McGuire v. Cunningham, 56 Mass Appellate Court, 160, 2002. Counsel does not believe any such case exists at the citation. It's a hallucinated case. Counsel identified this error through counsel's own subsequent review of the citations. Yeah, bro. More like because I yelled at you on stream and said this sounds like it was written by AI, so you were like, oh shit, even he figured it out. If Judge Gildea tears this apart, I better make sure those citations are legit. Damn right that's what you did, in my opinion, Attorney Burke. Literally, I called him out verbatim, word for word. I was like, bro, this is AI. I know, like, a motion that's... I didn't have time to shepherdize it, but, bro, I could tell you from the jump that Burke motion was written by LexisNexis's or something's AI program. Counsel identified this error through counsel's own subsequent review of the citations in the memorandum prior to any inquiry from the court or from opposing counsel, and brought it to the court's attention promptly thereafter by means of the original motion for leave to file a corrected memorandum. Counsel files this supplemental notice to ensure that the record before the court is complete and unambiguous. You filed them on the same day, sir. Today, as stated, Judge, please, Judge, please, I beg you, Judge, I'm telling you, like, I found the error on my own. Judge, I didn't submit an AI hallucinated case, and if I did, I caught it. Judge, please have mercy on me. Don't refer me for disciplinary proceedings. Don't sanction me, Judge. I beg you. Judge, please, I'm prostrating myself before Your Honor for mercy. I beg of you, Judge. That's what this may as well say. Judge, you don't understand. Please, Judge, I beg you. Judge, don't you want to save my legal career? Don't sanction me. Judge, you don't understand. Even if you, Judge, I know your clerk probably already brought this to you and you were going to scream at me about it, but Judge, I'm telling you about it. Have mercy on me, Judge. Have mercy. The laudacity. That's a great pun. Laudacity. I'm going to start using that more often. The laudacity. I love it. My point is, so, you know how they say things are a prayer for a relief to the court? Listen, this is giving prayer for relief a new meaning, ladies and gentlemen. 3 Clerk Monty Shriven, yeah. But this is giving prayer for relief, hello my dear friend, a new meaning. My goodness. He's like, Judge, listen, I bow before the greatness of Your Honor. Please take mercy and have pity on my meager soul. I've done everything I can to correct it, Your Honor. And even if you did shepherdize and find that case was completely fake before I submitted this, Your Honor, I acted with good faith, saved my legal career. Don't make me submit this motion in every single case that I file from now on, please, Judge. No word salad. He didn't admit to it being AI, but reading between the lines, you must understand. Think of the implications. Counsel does not believe any such case exists. Okay, well, counsel, where did you get the quote from? I don't think the counsel just made up this case. I think he didn't write the original document, at least not in its original form. So yeah, it's a fake. It's literally a non-existent case. So there's no way counsel could have been like reading the case and quoting from it and citing it in his original motion, because then he would have known it doesn't exist. Because he couldn't have been reading from it. Oh goodness. So now you want to see the fun part? We're going to shepherdize this shit. We're going to find where he got this hallucinated citation. Not him. We're going to find where the AI got it. Where did he pull this one out of? McGuire versus Cunningham. No shit, it is a real case. But it's not cited this way at all, bro. Oh, you can't trust these AIs at all. What year did it think it was from? 2002? Oh, this is wild. I found why it hallucinated the citation. That's hilarious. Oh, we're gonna prove exactly what happened. I can't prove what program he used. I'm not in his mind, but I'm gonna tell you exactly how this AI hallucinated this citation. Whatever AI he used, I can reconstruct it. All right. So give me 1 second. Come on, man. Let's go. What's this? Oh, hold on. No, I don't need it to open as a PDF. Thank you, though. Thank you. I don't need that. I just need to look. It's 510 pages. That's why it got all made. So where's the name Cunningham in here? And what's it have to do with 2002? No, it's not this, it's this. Okay, I got it. I thought it was a matter more close to Massachusetts. It's not. That was just a very long complaint about the Judge Rothenberg Center that mentioned a man named Cunningham and the year 2002, but it didn't have anything to do with the case. It was a complaint, but it was not what we're looking for. This is where it got the case from. It was actually a 2019 case, not 2002. It's called McGuire versus State of Robert Cunningham. And it's not from Massachusetts. It's from another state. Yes, yes. Here. Here. So it hallucinated a case based on this case, which is McGuire versus State of Robert Cunningham. It is from the First Circuit, but it's not from 2002. It looks like it's from 2019. Yep. It's this. It tried to summarize this case. It pulled a Kate Peter. It just changed the case name and title, and then it summarized. It probably tried badly to summarize this. There is no case, obviously, called McGuire versus Cunningham. There is a case called McGuire versus the estate of Robert Cunningham, which is definitely what the AI hallucinated into a different case. So then Tully's lawyer says, notwithstanding that, but Your Honor, the case Cronin v. Strayer stands for the same proposition. Well, I'll be the judge of that. Does it now? Does it? Well, we got to go pull up your initial motion, Mr. Burke. We got to pull up your initial motion to determine if what you cited in McGuire v. Cunningham is indeed reflected in Cronin v. Strayer. We got to check that out, Mr. Dilla. Not Mr. Dilla. What's his name? I don't remember the dude's name. Burke. He's probably not going to be a lawyer for that much longer because he can get slapped hard for this with sanctions. I don't know if he'll stop being a lawyer, but you can get in serious trouble for hallucinated cases. You have a duty under the rules to ensure, as a lawyer, to ensure that the cases are real. It's literally in the rules. Alright, so where's this thing from Tully? Where is it? Where is it? Yeah, here we go. Was it in the sir reply or was it in the actual motion? I think it was in the motion itself. Alright, where's this memorandum of law? No, that's not what we need. We need this specific site. We need to see what he cited it for, and then we need to compare it to the case he's now citing. Where's the memo of law? Yeah, alright. Where's the memo of law? Okay. Oh, okay. Microfinancial. Here we go! I found it. It's on page 6 of 43, 6 into 7, of Tully's initial motion for a protective order. So that's going to be docket entry 132. Now, he says, courts have consistently recognized their inherent authority to stay or quash subpoenas where the practical effect is to circumvent the discovery framework of a parallel proceeding. See McGuire v. Cunningham, and he cites that as a Massachusetts appellate court case. Every other case he cites is from the First Circuit or the Federal District Court. So he only has one state case. One state case, and it's a fake one. And he says that McGuire v. Cunningham stands for the proposition that a court's inherent power to manage discovery to prevent prejudice and abuse of process. So, let's go over to McGuire v. Cunningham. Give me 1 second here. I'm going to bring up the McGuire v. Cunningham one that we found, and then I'm going to search for, in that ruling, I'm going to search for anything related to the word subpoena. So I'm actually going to look for the word discovery. All right. Nothing. Discovery is not even mentioned in the case that the AI hallucinated about. All right. Now, we have to compare this standard that's argued here, recognizing courts' inherent power to manage discovery to prevent prejudice and abuse of process. Okay? Now, we need to go to this case. Okay? Cronin v. Strayer, which better be real. This one does seem to be real. In progress. Mm-hmm. 392 Mass 525. I got the case. Wouldn't you know it? It is a real case. Now, does this stand for the proposition to prevent prejudice and abuse of process? Well, I don't know. I do not know. I guess we'll find out together. Oh, British reporter Tal, would you mind? British reporter Tal is going to help us out. You can do it, British reporter Tal. He's struggling.
Cronin versus Strayer. Court Supreme Judicial Court of Edward Abrams. The plaintiffs brought this action seeking damages for defamation, intentional infliction of emotional distress, unfair trade practices, interference with contractual relations, and violation of the plaintiff Robert J. Cronin's civil rights. One of the claims is that the defendant defamed the plaintiff Robert J. Cronin by falsely writing to the Impaired Physician Committee, IPC, of the Massachusetts Medical Society, that Dr. Cronin was an impaired physician. 2. As a part of the discovery proceedings, the plaintiffs served deposition subpoena ducis tecum on the Society and on Charles H. Montgomery, a member of the IPC. 3. The subpoena sought a letter from the defendant to the IPC. 4. The records of the IPC investigation, and documents 5 concerning the investigation of the plaintiff made by the IPC at the request of the defendant. Pursuant to Mass. RCIV. P. 26, C. 365 Mass. 772, 1974, and 45, B. 365 Mass. 809, 1974, the Society and the IPC, through its chairman, moved to quash the subpoena on the grounds that the documents were privileged and confidential. After a hearing, a judge of the Superior Court denied the request for a protective order and declined to report his decision. The Society and the IPC appealed from the judge's order declining to quash the subpoena. We granted the Society's and Dr. Montgomery's application for direct appellate review. The plaintiffs ask us to dismiss the appeal because discovery orders are interlocutory and therefore not appealable. We agree. Thus, this appeal is not properly before us. We think, however, that we should express our views. Wellesley College v. Attorney General, 313 Mass. 722, 731, 49 NE 2D 220, 1943. We believe that there was no error in the judge's denial of the Society's motion to quash the subpoena. We summarize the procedural background. The plaintiff Robert J. Cronin and the defendant are licensed physicians, specializing in the practice of orthopedic surgery and are members in good standing of the medical staff of Cape Cod Hospital. The plaintiff joined the hospital staff in 1979, the defendant joined approximately 10 years earlier. The complaint alleges a number of acts of the defendant not here relevant and also alleges that, in the spring or summer of 1982, the defendant wrote the IPC, falsely charging that Dr. Cronin's ability to practice medicine is impaired by the use of drugs and/or alcohol. After investigation, on July 16, 1982, the IPC declined to make judgment on the case per se. The IPC stated that, at this point, the case is best investigated on a local level, and should our services be needed in the future, consultation or referral back to us would be welcome. On October 7, 1982, the Cape Cod Hospital through its Chief of Staff informed Dr. Cronin that its investigation on other charges against him commenced as a result of a request by the defendant was closed. On March 4, 1983, the plaintiffs filed their complaint, and on the same day, the plaintiffs notified the defendant that the custodian of records of the Society and Dr. Charles H. Montgomery of the IPC would be deposed on April 7, 1983. The Society and Dr. Montgomery applied for a protective order. The affidavit accompanying the application disclosed that the Society is a voluntary association of physicians, and that it is regulated by its own bylaws, rules, and procedures. The affidavit states that in 1978, the Society established the IPC to deal with matters relating to impaired or disabled physicians. In order to encourage referrals, the IPC adopted a policy of strict confidentiality. Written referrals to the committee and information developed by the committee in the course of its work are kept confidential and are not exhibited to or provided to third persons. The IPC believe that only by assuring the confidentiality of information provided to it and maintaining the anonymity of persons cooperating with the committee can it promote the trust and reliance which is essential to the committee's work. Accordingly, the Society and the chairman of the IPC ask that the subpoena be quashed and that their respective depositions not be had. The judge denied the Society's motion. In his memorandum and order, the judge noted that GL Circa 231, Section 85N does grant such committees immunity from liability for good faith actions. But the judge concluded that the statute does not grant either the defendant or the committee immunity from discovery. The judge further noted that the Board of Registration of Medicine has a similar function to that of the IPC, and that Board of Registration in Medicine complaints and complaint files are public records. Subject to exceptions not here applicable. See 243 Code Mass, Regs. Section 1.028, 1, 1979. The judge ordered that discovery or information obtained as a result of discovery not be disclosed to persons other than the parties or their counsel or except in the course of further judicial proceedings in the case. The judge expressly left open the question of the admissibility of evidence obtained as a result of this discovery. Ripeness of the appeal. The appellants do not challenge the general rule that the discovery orders are interlocutory and not appealable. See Borman v. Borman, 378 Mass. 775, 781 to 782, 393 NE 2D 847, 1979. See also Bate v. Probate and Family Court Dept, 385 Mass. 854, 858, 434 NE 2D 642, 1982. Rather, they argue that, because this appeal is brought by two non-party witnesses and involves a matter of substantial concern, the rule should not apply. They acknowledge that a non-party witness can obtain appellate review of an order compelling discovery by disobeying such order and appealing from the subsequent contempt order. See, e.g., Matter of Roche, 381 Mass. 624, 625 N. 1, 411 NE 2D 466, 1980. The appellants assert that we should permit this appeal because no legitimate purpose is served by requiring witnesses to invite contempt in order to obtain appellate review. We do not agree. Orders compelling the testimony of witnesses are among the most common of everyday incidents to the process of disposing of cases, and objections on the ground of privilege are frequently raised. 4 Moore's Federal Practice Par. 26.83, at 26 to 599, 2D ed., 1979. Borman v. Borman, 378 Mass. 775, 784, 393 NE 2D 847, 1979, and therefore, acceptance of the appellant's position would open the door to countless appeals from orders heretofore uniformly deemed interlocutory, thereby swelling appellate dockets already too large and delayed. 386 F2D 691, 695, 2D CIR 1967. To accept the appellant's view is to invite the inundation of appellate dockets with what have heretofore been regarded as non-appealable matters. It would constitute the courts of appeals as second-stage motion courts reviewing pretrial applications of all non-party witnesses alleging some damage because of the litigation. Borden Company versus Silk, 410 F2D 843, 846, 3D CIR 1969. C, e.g., Honig versus E.I. DuPont de Nemours and Company, 404 F. Moreover, C, on finding the right to get appellate review of discovery orders to cases where the party, or witness, against whom the order was directed cared enough to incur a sanction for contempt is a crude but serviceable method of identifying the most burdensome discovery orders and in effect waiving the finality requirement for them. Maurice vs. American Academy of Orthopedic Surgeons, 726 F2D 1150, 1158, 7th CIR 1984. See United States vs. Arthur Anderson and Company, 623 F2D 720, 724, 1st CIR, cert. Denied, 449 US 1021, 101, 66 LED.2D 483, 1980. Well-established doctrine regarding the appealability of interlocutory orders suggests that the burden of incurring a contempt citation is not an unreasonable one to impose on a party, or a witness, seeking review of a question that will otherwise become moot. The remedy of the non-party witness is to refuse to answer and subject himself to civil or criminal contempt. Kaufman vs. Edelstein, 539 F2D 811, 814, 2D CIR 1976. Because the policy of not reviewing interlocutory matters stems from the burdensome nature of piecemeal appellate review, Capadona vs. Riverside 400 Function Room, Inc., 372 Mass. 167, 169, 360 NE 2D 1048, 1977, we declined to adopt a construction of our rules which would permit non-party witnesses to appeal discovery orders. The appeal is dismissed.
And you cited this for the proposition that courts have inherent power to manage discovery to prevent prejudice and abuse of process. and you want to use this to argue that courts have consistently recognized their inherent authority to stay or quash subpoenas where the practical effect is to circumvent the discovery framework of a parallel proceeding. No. 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 Do not pass go. Do not collect $100, $200. Nope. Nope. Unless there's something hiding in there past the end of the first part, which I will read before we get to July 10th. Nope. Absolutely not. What in this decision, Cronin v. Strayer, 468 NE 2D 143 392 Mass 525 Mass 1984. What in there stands for there wasn't a parallel proceeding. Furthermore, Cronin v. Strayer is the denial of an interlocutory appeal from a motion to stay or quash a subpoena that was denied, and the appeal was denied. All right, counsel. Sign your walking papers. I put it through the towel test and it failed. It failed. That is not what that case stands for. There was no parallel proceeding. Oh my God. And that was it is 8 at night. I'm up past my bedtime. That was me, just my cursory review of the case you want to subset. That's not a thing. You don't get to say, Your Honor, the case was fake. So here's this case that kind of stands for the same thing. You don't get to do that. Judge Gildea, listen. Judge Gildea is not having a good night. Let me tell you right now. Oh, he's going to be in a mood. Listen, if he took even a second to look up that case, which I just did, Cronin v. Strayer, and then was like, wait a minute, what did you actually tell me that McGuire v. Cunningham, the non-existent case, standing for, counsel? And now you got me reading about how you can't appeal a interlocutory discovery order like the denial of a motion to quash, like I'm going to do for your client, counsel. Sanctions! I want them all sanctioned. Everybody sanctioned. All of you. You have to get on a flight, and I'm sending you somewhere. Good luck. Figure it out. You pay for it, and it's not going to be Cancun, and you can't go with attorney Melanie Little. I'm sending you to whatever Cuban jail they put Santo Traficante in. That'll teach you to cite fake cases and then try to supplement them with real cases that don't even stand for what the fake case you claimed it stood for. Oh, now I'm really mad. I haven't been this mad since I found out John O'Keefe was texting Brian Higgins about hookers. You don't understand. I am so mad. All right. That's enough. I'm going to hurt my voice. That was a good towel. Listen, you got a very special towel rant if you stayed around for the end of this one. We did shepherdizing. I yelled about things. I issued sanctions. I'm pretty sure I sent some of the lawyers to Fiji. I'm not really sure why I picked Fiji. I just thought it would be a fun place to send them. Then I realized, well, if you're going to sanction them, Grant, they're really not supposed to be having fun. So then I was like, well, damn, I don't really have any ideas. So I just sent them on a plane. They just have to live on a plane. That's miserable. How about that? Oh, goodness. Yes, exactly. Judges can order lawyers to take planes. I'm pulling a Judge Cannoni. I'm not ordering Alan Jackson onto a red eye as 20th Century Foxy or 3 Clerk Monty. So, wonderfully checks out. Oh, that's right. Melanie Little, the packages. Hold on. All right. I'm gonna have to like have something read out. We're not just gonna have nothing. That's it. I'm playing you a video of goats, and while I do that, I'm gonna go check whether or not the Melanie Little gear has arrived. Then you'll get an extra special towel bonus. Alright. I'm just gonna play you a video. Actually, you know what? I'm gonna play you a video of the Iranian Foreign Ministry spokesman talking earlier today in English about the developments related to the Strait of Hormuz. Because you know what? You know, other people play like songs during the intermissions. I do that sometimes. Sometimes we play the goats, but no, today I realized I actually translated this into English. So you're gonna watch a video from the spokesman for the Iranian Foreign Ministry, and he's gonna be talking about how there's no meetings planned with the Americans. So yeah, have fun with the Iranian Foreign Ministry spokesman, and you know, I'll be back in a few minutes.
روایت درست معلومه کدوم روایت هست. روایتی است که سخنگوی شما اعلام کرده خیلی سریع. ما اساساً برنامه‌ای برای دیدار با طرف‌های آمریکایی در هیچ سطحی در این چند روز آتی نداشتیم که بخوایم منصرف بشیم. از اول هم آقای غریب‌آبادی این رو اعلام کردن، هم بنده دیروز این رو صریحاً عرض کردم. آنچه که در دوحه در احتمالاً فردا انجام خواهد شد، گفتگو در مورد اجرای بندهایی از یادداشت تفاهم هست، از جمله بند مربوط به آزادسازی دارایی‌های محدود شده ایران که با طرف‌های قطری خواهد بود. لذا بازم تاکید می‌کنم هیچ نشستی در هیچ سطحی با آمریکایی برای چند روز آینده ما برنامه‌ریزی نکردیم. اجرای بندهای مختلف یادداشت تفاهم از جمله بند مربوط به آزاد شدن دارایی‌ها در حال انجام هست. بند 11 و همه مقدمات لازم تمهید شده و امیدواریم که انشاءالله کار به نحو مناسبی پیش بره و به نتیجه مطلوب بره.
So there's the update from the Iranian Foreign Ministry spokesman. Also, I heard a rumor that I teased goats. Yes, well, I've never teased a goat, but I heard a rumor that I mentioned there might be the original goat video. Yes, ladies and gentlemen, these are our goats. These goats were displaced along with 1 million people from southern Lebanon. Now, they're slowly going back. You know, I'm hoping the IDF leaves southern Lebanon. It's really hard to get them out of Bin Jabil and Nakura and like Qaim. You'd be surprised. They really don't want to leave. But, you know, they're working on it. They blew up some tunnels. But the point is, these goats were displaced from southern Lebanon on March 9th, 2026. This is them walking through the streets of Beirut, the Lebanese capital. Save the goats. We hope that they're home and safe. I'm going to build them shelters. All right. I have a big day tomorrow. I'm going to be reporting from the Karen Reed trial in Plymouth. God bless you all. Got to go set that up. Got to figure out what I'm doing, my plan for tomorrow, how I'm going to get it all done, what I'm going to do, etc. Towel loves you all very much. I got to do Tippecanoe and Tyler 2 before we get out of here. If you've never been here for Tippecanoe and Tyler 2, at the end of streams, not only do I bring out the Towel channel mascot, his name's Pete Bunny Towel. He loves his friend Francine. God bless you all. Thank you so much for watching. Kevin from South Boston, you're right. Leave the goats alone. Act right. God bless you for being here. And the rest of you, Pat Ray, you're wonderful. thank you for being here, 20th Century Foxy and all my towel friends. But this is in honor of the one and only Triple Bob. We call this Tippecanoe and Tyler 2. This is where I list the presidents in order to check my mental acuity at the end of streams. My name's Grant Smith Ellis. Thank you for watching Towel News. Again, you can support via subscribing, liking the channel. We're almost at like 12,000 subscribers on Towel News now. That's wonderful. This is the last day of the month, so God bless you all. Thank you for supporting the Towel channel. There's a Venmo, there's a Cash App, there's a PayPal. We'll do that in a minute, though. So here we go. All the presidents in order to the best of my abilities. President Washington, then you had, and this is Tippecanoe and Tyler too. So President Washington, then you had President Adams, then President Jefferson, then President Madison, then President Monroe, then President Adams Jr., then President Jackson, then President Van Buren, then it's like William Henry Harrison, and then I think it's Polk, and then Taylor, and then Fillmore. Okay? Then you're going to get Pierce, Buchanan, Lincoln, Johnson, Grant, Rutherford B. Hayes, Garfield, Chester A. Arthur, Cleveland, Harrison, Cleveland, McKinley, Teddy Roosevelt, William Howard Taft, Woodrow Wilson, Harding, Coolidge, Hoover, FDR, Truman, Eisenhower, Kennedy, Johnson, Nixon, Ford, Carter, Reagan, Bush 1, Clinton, Bush 2, Obama, Trump, Biden. I think I got, hello, Sarah B. Creative. I think we had a frame drop there, but I think you heard me get through Tippecanoe. I missed the 25th president. I did. No, I said McKinley. Cleveland, Harrison, Cleveland, McKinley, Teddy Roosevelt. It was quick, but yeah, he's in there. He got shot in 1901 by an anarchist up in Buffalo. Then that damn cowboy, Teddy Roosevelt, became president. Yeah, it's not a worry, Sarah B. Creative. I just said it really quick. No, don't worry. Yeah, can't leave Mr. McKinley out. I wouldn't want to offend him. I left Mr. President Truman out one time. I never forgave myself. You're wonderful, Sarah B. Creative. It's so good to see you, my dear friend. By the way, if you ever do catch me missing one, I mean, 70,000 million bonus points. You know, so many bonus points, T.A. Sarah won't know what to do. But yeah, you got extra videos of goats. We had a great day. I got to start, like, preparing. I got to get ready, determine what I'm going to do tomorrow, how I'm going to do it, etc., etc. I got to figure out, like, what the hottest day is going to be. I think that's going to be Thursday. Oh, Pat Ray, God bless you for your support. Thank you for being here today. It was great to hang out with you. But yeah, I got to figure out like what I'm doing tomorrow, how I'm doing it, where I'm going to do it. But yes, you're wonderful. Thank you all so much for watching Towel Channel this month. Thank you for being you. As I mentioned, there are ways to support. You can like the channel. There's super chats. As I mentioned, if you want to help Towel out, there's ways to donate. You can, but please don't feel obligated. The whole point is if you don't have the resources, this is supposed to be a place where you can get information regardless of your resources. But if you do want to support, there's a Venmo at Grant-E1. There's a Cash App, money sign Grant Smith Ellis. There's a PayPal, paypal.me/Grant Ellis. You can find those links in the chat. My goal here is to educate, inform, and entertain you. 20% entertainment to buffer your brain from trauma or just lots of intense court documents. 40% information, 40% education, designed as such to engender cogent public discourse, thus warding off the usurpation of our forms of government worldwide. If you like what you see here and you really want to pay it forward, do consider doing a small act of service and kindness for people around you today. Pete Bunnytail loves his friend Francine, and he appreciates all of you and your consideration of his request. It could be something as simple as, safe travels to you, Pat Ray, as well, something as simple as reaching out, as donating to a charity that helps our homeless service members or veterans. There should not be a single veteran or service member in the United States homeless against their will, or we have failed as a society, ladies and gentlemen. You can donate and help them today. You may also consider donating to an animal shelter. Pete Bunnytail is not an animal, but he loves our fur friends, run by veterans or that helps veterans or our service members. Great way to help our fur friends, great way to help our service members or veterans. Now, what if you can't find such a charity? Do consider a donation to animal shelters in general. Sarah B. Creative, I'll let Towel Girlfriend know. She's wonderful, and you are loved and adored as well, my dear friend. You may consider a donation to animal shelters in general. Great way to help our fur friends. If you're in the UK, consider a donation to The Big Issue. Great way to help populations experiencing homelessness in the UK. But it doesn't have to be a donation. It can be something as simple as smiling at someone on the street, reaching out to a friend or family member you haven't heard from in a while, or yes, even giving away 200 tomato plants like Francis Futrell did one time and having them designated honorary towels during the outro forevermore. And yes, Larson Campbell, you're going to love our friend Triple Bob. He loves Tippecanoe and Tyler too. If you do exclamation point Tippecanoe, you got to spell it a certain way. The bot even does the Tippecanoe song. It's great. But yes, in that way, ladies and gentlemen, may we pray the current realpolitik continues to change from one centered on preserving, expanding, and demonstrating our power to instead one centered on preserving, expanding, and demonstrating our capacity to engage in small acts of service and kindness rooted in unconditional love, therein allowing us to live up to our tabel eudaimonia or summum bonum, our greatest good in the ancient Greek or Latin respectively, and in turn helping us bring about a new digital epoch defined by Aquarius, the water bearer, standing tall and carrying the towel. I believe it's possible because of you all. God bless you all. Thank you so much for being with me today from a very tired towel with a tired towel voice, and from a towel with a lot to do tomorrow. My name is Grant Smith Ellis. God bless you. Thank you for being you. Thank you for being with me as I sign off tonight on Towel News. It is 8:19 p.m. on this Tuesday, June 30th, 2026. That would make it 2:19 a.m. in South Africa, 3:19 a.m. in Tel Aviv, Israel, and 3:49 a.m. in Tehran, Iran. That would be Wednesday, July 1st, 2026. God bless you all. Thank you for being with me today. Thank you for being you. Save the goats, save the United States of America, and may God protect us all. My name is Grant Smith Ellis. Until we see each other again, be well. God bless you, friends, and thank you so much for being with me today. It meant a lot to me. Have a great rest of your day, afternoon, or evening, whatever the case may be. And from me and the rest of you towel friends at Towel News and the goats, God bless you, be well, travel safe. What's this? A special bonus towel coming back to say special thank you to Sarah B. Creative for that wonderful super chat. God bless you, my dear friend Sarah B. Creative. You even got towel to restart the stream. How fun is that? You are wonderful, Sarah. And you are creative. Sarah does be creative. It's true. But yeah, look at that. Bonus towel. Hashtag bonus towel. So those of you who stay around at the end thinking, is he ever just going to start up again one time? I did it now. Thank you for being you. Pick a handle. God bless you, Sarah B. Creative. God bless you, towel friends. I'm out for the night until we see each other again.